This order. My apologies for being late. A little traffic. Madam Clerk, can you call roll call, please?
Member Nee?
Here.
Nee present. Member Washburn?
Here.
Washburn present. Member Pilpel?
Present.
Pilpel present. Member Sims?
Present.
Sims present. Member David?
Present.
David present. Member Highland?
Present.
Highland present. Member Oka?
Present.
Oka present. Vice Chair Fisher?
Present.
Fisher present. And Chair Grant?
Present.
Present. You have a quorum?
Great. Let's talk about any agenda changes. The first one, if you guys know something, please jump right in, that I know of is that item number 6, file number 13012, the complainant asked to have that issue, this complaint continued, and the respondent was in agreement.
I have two other changes.
That was item number 6.
I'm sorry. Deputy Controller Monique Zamunda for item number, 13014, file number, has asked, she won't be here till later on because board meeting is going on, and asked that her item be moved later in the agenda, or that she'll be a little late.
Okay, which number is that? I'm sorry.
That is, it's file number 13014, and I received an email about 3 o'clock.
She's at the end now.
Yeah, she's at the end, but she just wanted to give a heads up. Okay. And then also for the first item.
12007?
Right, correct. Peter Warfield, there's a conflict since the board is going on. He had some business to attend to there and asked if it could be heard later on in the agenda.
In the agenda today, though?
Yes.
Okay. Now, okay. I'm sorry, who are you? Can you come speak in that for a second? I'm sorry. Thank you.
Slate Aid from Supervisor Campos' office, and I have to pick up my daughter from daycare, so I can't stay later.
Okay.
So those are the requests. Member comments?
Yeah, I'd like to get members' comments. I'm sorry, sir.
Yes, hi.
Hi.
My name is Francis Nguyen. I'm the Deputy Director for the Assessor Recorder's Office.
Okay.
On complaint number 13012, I heard that you said the respondent agreed to the continuance. Was that correct?
Yes. Did you?
No, we object to the request for continuance.
Okay. So, Andrea, correct me.
So an email was sent out, let's see, I have it right in front of me. Okay, an email was sent on July 3rd. You're Francis?
Yes.
Okay. Stating that the complainant had asked for a continuance, they would be out of town.
The complainant cannot
Right.
make it, but
And did they respond?
we object to the request for continuance.
Okay, I didn't receive an email stating that from you.
Okay.
Okay, so we were wrong. So we assumed that you guys had agreed to this continuance, but you do not agree to it. Okay, cool. Okay, so we have all these and we'll deal with it one at a time now. Okay, so regarding file number 12, so we'll still with the first item, 12007. I'd like to open up to the members. The first request, EOT and the legislative aid is here and cannot stay later, and Mr. Warfield has asked to have this heard later. So, Member Pilpel.
Thank you. So we'll get to the substance of the item when we get to it. We did have today the letter that I sent on May 16th that's before us. I believe there was a response from Supervisor Campos's office, but that's not before us. Does Supervisor Campos's office have copies of that response letter? Sorry, there was a letter from the committee dated May 16th, and there was a response from your office, and I forget
Yes.
the date of that.
May 21st?
Sounds good. Do you have copies of that letter for the group?
I'm sorry, I have one copy. I
Okay.
didn't make copies.
While could you perhaps make a set of copies, because we couldn't, it would be helpful if we could get some copies of that.
Oh,
piece
sure,
of
I'm sorry.
correspondence.
I thought that was something that the clerk
We
did.
normally do, but it would be helpful if that could happen. If that-
Okay.
So this is the letter that is the response from Supervisor Campos's office to your letter?
Correct. And
Okay.
that should be before the body in order to
Okay.
deal with this. So if you can
But she-
handle that and see if we can get Mr. Warfield back, then we can probably hear it relatively
She needs to leave.
soon.
What time do you need to leave?
I need to leave by 5:15, so I've...
So
Yeah.
this definitely needs to be heard.
So
And
we're-
what did Mr. Warfield say?
He's camped
Mr.
out
Mr.
downstairs.
Warhill did not give a time as to when he would be back. He just said that he had business to handle and that he would be back when the item is called later.
He's
He didn't ask for continuance or anything. He didn't
He
state
did not.
that.
He
just
just said
state that.
later. Okay. Okay. Great.
Hi, Ray Hartz. Mr. Warfield is in the Board of Supervisors chamber wanting to make public comment.
Oh, okay.
I can let him know that this has come up, and
Would you
perhaps he'll decide to come back up right
Because
away.
it's the first item?
Sure.
Okay, thank you. I appreciate
So I
it.
would suggest that we'll get to this in probably
Before 5, because you're the
10
first
minutes or so.
item.
Okay, so
So-
I will go make copies and come back.
That would be very helpful.
Thank you. Okay. So
So that's as to item
12007, yeah,
Item 2, as to item 6.
regarding Glad Tidings Church. So we need to make a motion because the respondent is contesting the continuance that was requested by the complainant.
Can I just ask, in the future, when we get a request for a continuance like that, particularly if it happens after the packet has been published, if we can have copies of that continuance request before us? Because we've heard it, but to understand it in the timing.
Well, he was just out of town, so,
I understand, but that continuance request itself, a copy of that email should be before us, and it's
Okay.
not.
so the issue at hand is that there is a continuance request. So let me open it up to you guys, and the respondent is not in agreement and wants to object to that. So I'd like to open it to the members. Is there a motion? Any conversation? What you guys would like to do? Member Washburn.
I think this matter should be continued. If the complainant can't be here, we really can't have a fair hearing of the matter. So I think it only makes sense to continue it.
And Andrea, the letter was July 3rd, I just want to be clear that we received it, and the complainant received the same letter for this request?
Correct.
Okay. But we didn't receive any email or anything from the respondent saying that they objected to this continuance or
No.
anything? Okay.
Could I
Member
follow
Pilpel.
up with Mr. Nguyen? What, if you could approach, what is the harm from your perspective by continuing in a month?
Well, on advice of counsel, our office cannot disclose the official information.
You know,
And
that's on the substance. Would you be able to come back next month, and can we hear it then? Do you have a huge objection to that?
if that's what
You'll live with
you
that?
vote on that, we're
Right.
fine.
I think so because,
Okay.
I mean, we'll take it to the task force, obviously. But just because we didn't get a response from your office, if you understand.
Okay.
And so, because the person was out of town, they did
Okay.
rescind that request.
Okay.
So let's take this to a vote. Let's see if there's a motion. Oh, Member Washburn?
I move to continue this item till next month.
Second.
Oh, who's that second?
Member Nee?
Oh, okay. Thank you. Is there any public comment on this item? If not, then I'd like to, I'd like to move that we continue this to the next meeting in, what is this, August, our August meeting.
Okay.
Okay.
So can I go?
Yes, you
Okay.
can go, and then we will send you another an announcement that we need you to come back in August for our August meeting.
Okay.
Okay, thank you very much.
Thank you.
Okay, so that item's
And
taken
we're-
care of.
And that's without objection?
Without
Is that
objection.
passed without objection? Did I say that? Okay,
Still it's helpful to say that, without objection.
yeah. So this motion passed without objection. Okay, so for the third item, we are waiting for Mr. Hartz, who is going to let, what was the third item?
That was the controller. It's already at the end of the agenda, so I don't think we need to do anything to move that.
Yeah, I don't think we need to do anything for that. So
Okay.
we're actually just waiting for Hillary. So in the meantime, I'd like to just see if the other complainants are here. Hold on one second. Shh.
Do you have something? You're leaping up and down?
Wait, let me just do this in order. Let's just try to do it in order. It's okay.
Patterson, San Francisco Arts Commission, I'd hope to make a request to move our item to number 1 because I too have to leave early. However, Howard Lazar is also here and can testify to the 2 agenda items. But I would defer to Supervisor Campos's office, but I also defer to you. If you want to keep it going, then we're ready to move forward. Thank you.
Okay, great. Okay.
I just had one other comment on the,
Sorry, I'm the complainant on both
Yes.
those cases,
Yes.
and I just want to keep it the way it is.
It's a complaint on the second case. Yeah. What
Keep
case?
it the order it is. These people have a history of
Okay, I
shifting.
got it. We're
Thank
good.
you.
Thank you. Okay, so right now, we have agreed to continue item number 6. We are trying to move forward with item number 2, hoping that Mr. Hertz comes back, and then we will move forth. So now we know that Paula Detesh is here, Kate is here for item number 3.
Lazar?
And Mr. Lazar. And for item number 5, number 6 is continued. Ray Hartz is here. Is Mr. Herrera here? I can't see. Okay, his representative, thank you. And is Mr. Rosenfeld here for item number 8?
We heard that Ms. Zamuda
Oh, that's the
will
one that's going to be late.
be here later.
Okay, and then is Mr. Ledford here? Okay, and is a representative from the Office of the City Attorney? Okay, great. Okay, thank you. Okay.
And I just had one other comment on our membership block. I think we should either list Member Oka also as a holdover, because he is too, or we should not list anybody, because we don't, although 3 of our members are holdovers, they're not second-class citizens, they are members of the task
Mr.
force.
Oka's not a holdover.
He actually is.
No, he isn't. He was just brought on.
He actually is. His term expired this year.
Okay. we can do
Anyway,
this later. Yeah.
all I'm
So-
suggesting is that either all or none, but it looks funny to list some.
Great.
Thank you.
So, trying to wait to see if he's going to be able to get back here and see what's going to happen for item number 2, because I'd like to move forward with the agenda.
There we go.
Great. Everyone came at the same time.
Excellent.
Thank you, Mr. Hartz, for doing that.
Thank you very much. Copy for you, copy for me.
So can you call item number 2, Madam Clerk?
Item number 2, file number 12007, Education Outreach and Training has referred 12007, Library Users Association, is Supervisor Campos for responding late to an immediate disclosure request and redacting information from the Bernal Heights Branch Library mural, related documents inappropriately.
Right, so at this time, I'd like to, this is a case that we've heard, I'd like to ask the chair of the EOT to kind of bring us up to date on what actually occurred and give us the situation.
Great. So this item was heard by the task force back in April of 2012. Was referred to, an order was determined at that time, was referred to the Compliance and Amendments Committee, which heard it, and I'm sorry, sometime in 2012, it was referred back to the full task force and was referred further from the task force to the EOT committee, which attempted to hear it twice. At the first meeting, there was a continuance requested and granted. At the second meeting, there was no appearance or request from Supervisor Campos's office. The committee discussed it at some length, how to proceed. There was a decision to send a strongly worded letter, which you have before you, dated May 16th, from the committee to Supervisor Campos, expressing the view of the committee. It was my intention as the chair of the committee to hold a hearing with the complainant and the respondent, Supervisor Campos, or his representative, and determine if, in fact, they have procedures in place to timely respond to such requests. We were frustrated that there was no appearance or communication at the second meeting, which resulted in the letter that you now have before you. The response dated May 21st from Supervisor Campos's office, including their policy and procedure, and I think it was probably a strongly worded apology for their non-attendance. But we will hear from both the complainant and the respondent. That's my summary of where we are. The item is before the full task force and open for a variety of potential actions, ranging from doing nothing and concluding the matter to referring the matter to an outside agency or anywhere in between. I turn it back to you.
Okay. So, Mr. Warfield, if you'd like to come up and kind of update us what your concerns are, or if you still have any concerns even after, I'm assuming you've seen this letter from May 21st. Have you? From from Supervisor Campos's office? In response to Chair Pilpel's?
I have not seen a response, and I'd like to ask whether it was sent in any fashion to Library Users Association by your administrator. I don't recall receiving any response. As I said to the administrator before the meeting began, I was very troubled that even the EOT letter, which is the most recent action, is not in the agenda packet, and I believe that seriously deprives us of the publicity and the awareness from the possible public that would be interested, and any member of the public who wants to understand what's going on or what this is about would be deprived because there is no EOT letter in the agenda packet.
Madam Clerk, do you want to respond?
Mr. Warfield is correct that the letter that Chair Pilpel wrote and also the response from Supervisor David Campbell is not in the packet, and I take responsibility for that.
Okay.
But all the items are there.
Okay. And we have
Did I get sent a copy of the Campos letter?
the
I would have to double check. Right now I don't recollect.
All right. Well, I think there's a really serious breakdown in basic ability to function in the most basic way here, and it's very troubling.
Okay.
The agenda, neither is the agenda clear as to what the purpose is, and it hasn't been clear since it went to the EOT, where it was referred from Compliance and Amendments Committee to see what the status was. The agenda here appears to be saying this is a hearing on the case. File number 12007 EOT has referred file number so-and-so for responding late to an immediate disclosure request and redacting information from Bernal Heights Branch Library mural-related documents inappropriately. That was settled in April, more than 1 year ago. What the EOT also was concerned about was first the delay by Supervisor Campos's office and then the no-show at their last meeting. They simply didn't come, nor did they evidently notify anybody. They did show up after everything was over and the EOT had decided to hear the matter without their presence because they'd waited long enough. But I think that was a concern of the EOT as well, the law requiring that folks show up for any hearing, that the respondents show up for any hearing.
So my question is now, seeing this letter and their explanation, does this satisfy you? What is it?
I certainly am not going to comment on a multi-page letter, which I have just gotten in my hand the very moment that I'm supposed to talk about this case because of your negligence in sending it to the parties.
Okay.
I think that's outrageous. You also have procedures that say material that's to be considered at a meeting is going to be provided in the agenda a certain amount of time prior to the meeting, and if it's sent later,
Madam Chair, point of
and if
order.
it is sent later, that it would, it's the option.
Point of order, Madam
There's an
Chair.
option.
Point of order.
I would, respectfully, I would suggest that our questions of the complainants and respondents be put off till after they have made their opening remarks and we have received facts and evidence. from the complainant and the respondent.
Okay. Well, do you feel like you need to have this item continued since you just received that for the next meeting? What is it that I would like to know what it is that you'd like?
This has been a mess.
Okay, so
It's a year and a half since more than a year and a half since the complaint was filed, and more than a year since the order of determination was found. The agenda doesn't seem to be indicating what the issues are. The agenda packet doesn't include the latest action by the EOT, which was a letter. We did not get a copy sent from this letter, which is this letter from David Campos, which is weeks old, and I really don't know what to say.
since you feel that we haven't, I'd like to perhaps suggest that we continue this item till you have been able to fully look at all the letter that was sent from Supervisor Campos's office, since you have not, as you say, been privy to what they have written, and it's a multi-page letter. If that is an agreement, rather than going through all the facts and evidence of what's going on, because you haven't been up to date. So our apologies on that, or, I mean, that's pretty much what I'd like to offer you right now.
I wouldn't object, since this looks like it's going to be maybe settled when I'm in my grave. But what I'd like to say is that there's a considerable amount of information that you certainly might take into account while I'm still compos mentis, such as the fact that Supervisor Campos did not reply within 5 days of the order of determination, which came a year ago, but rather took more than a month to reply. I can also tell you, for example, that there are other statements in his letters, for example, on your page P44, where he talks from January 31, 2012, about the redactions in paragraph 2, and he claims, please note that we did not redact any business contact information for government employees or private parties. Well, if you look at your own file here with the complaint that we filed at the time, it's very clear that Mauricio Vela on page P42, home/office phone number, was redacted. Roberto Y. Hernandez, Presidente, Latin Zone Productions, every contact bit, including email, was redacted. Excuse me, Latin Zone Productions doesn't sound to me like a private address. That's on your page P40. So I certainly would like the agendas to be correct, as well as the contents of the agenda packet. And the EOT, as I understood it, was very concerned about the no-showing, the non-appearance, and that is potentially, I think, a complaint internally that you might be filing or determining on your own, and that needs to be shown in the agenda along with the letter. The letters now.
Okay. So I would like, so my understanding is that you're fine with this being continued to the next meeting so that you can be fully up to date with the letter from Supervisor Campos, and everyone can be up to date. We all have the letter here.
When did you get it?
Force. I had it, I don't know when, as the administrator said that she...
5 minutes ago, 5 days ago?
Minutes before the meeting. So
I don't see how you can imagine that you would be able to... Huh?
I had seen it before as the chair. So this letter from, I hadn't seen this letter from Supervisor Campos, so that is true. I had seen the letter from our chair of the EOT. So I saw that letter, and I did not see the response. So I would like to request a continuance till next month, because I think that it needs to be prepped. Everyone needs to be on the same page. So I'm asking you as the complainant if you have any objection to that.
You said, am I fine with it? I'm not fine with the background here, with what seems to me really incompetence. Because of the circumstances, and because I do think it's appropriate to give folks a fair shot at a fair hearing with things being appropriately considered, including yourselves, I would not object if that's what you wish to do.
Okay, thank you. Supervisor Campos' office, I'm sorry, I forgot your name. Are you okay with us continuing this till next month as well?
Absolutely.
Great. Can I, is there a motion on the floor to continue? Member Pilpelt?
I'm fine to do that. I thought while Ms. Ronan is here, if she could also take a moment, since she was not at those 2 meetings of EOT, to give us just a moment or two on the procedures, and we can follow up further at the next meeting. But I think that's kind of where we are, is whether they have procedures in place, and I'd like to hear very briefly about that.
That's what's on the letter that you've provided.
I understand, but
Correct.
I'd like to.
But if we're going to do this next month, I'd like to hold off so that we can read the information. I want to hold off till next month, if that's okay. Great. Thank you. Can I get a motion if anyone is in agreement with this?
Move to continue.
Do I have a second?
Second.
Is there any public comment on this particular issue?
The members of the task force are probably unaware of the activity of some of us in dealing with the administrator. And of course, most of you weren't here when Mr. Rustum was the so-called administrator. And I'm sure you don't remember Mr. Rustum's predecessor, who was an accomplished administrator. So if you want me and the other advocates to start copying you on our missiles to the administrator regarding various things, we would be happy to do it. This is a clear case of a job not being done, not being thought through. And it's not, I don't know. I mean, some of us don't like to be hypercritical, but at times I think it's appropriate. My order of determination in the case that was heard June 5th, I still haven't seen it. That's over a month. It's probably closer to 6 weeks. I have no idea when I'm going to see it, and I have a lot of interest in finding out what this task force ultimately determined, because I don't think that the minutes of the meeting reflect properly what happened. Thank you.
Thank you.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. I've said it once, I've said it many times, if you can't follow the proper rules for running meetings, then we have a real problem, because it's your job to make sure that other public meetings in other bodies are being held. If you have not had access to all the appropriate documentation, if it's being provided to you at the last minute without parties to the case being able to review it properly, to go forward, it would be a travesty. I think that it's very simple. These things have to be done right. They have to be agendized properly so that the participants know exactly what the issues are before the task force. And I'm reading this and I don't understand what the issue is. I know that this case went to the compliance amendments and it came back to the task force, then it went to EOT and it's come back to the task force. And in the same time, I have no idea exactly why that is. If someone has an order of determination, it goes to compliance and amendments, and they either comply or they do not. And if they don't comply, then it should be sent back to the task force for further action, with the recommendation, hopefully, to refer it to some appropriate body. But basically, this has been bouncing around and bouncing around and bouncing around. You cannot hold public meetings where the documents are not there. And now we're also talking about public meetings where the documents are not there for members of the public. I review each and every one of these cases and each and every packet, just like I would expect each of you to do, so that I can get up here and talk with some level of understanding about what it is I'm saying. And if I didn't have access to these records, especially ones that were provided in May, we're talking more than a month ago. And Mr. Warfield didn't get copies of it. They weren't included in the packet for you. There's really absolutely, in my mind, no way you can consider this and consider it to be a fairly, hearing it fairly.
Thank you. Is there any more public comment on this issue? If not, it has been moved and seconded that we continue this item. I'd like to take a roll call vote on this.
Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Pilpel?
Aye.
Pilpel, aye. Member Sims?
Aye.
Sims, aye. Member David?
Aye.
David, aye. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. Member Fisher?
Aye.
Fisher, aye. And Chair Grant?
Aye.
You have 9 ayes.
Okay, it's been moved to continue this to next month's meeting. So if there's any documentation or anything that we need from either party, Madam Administrator, make sure we have it. Thank you.
And we'll have these two things in the...
We already have, yeah, and we have these two, so we'll include those for thank you so much. Okay, let's move to the next item.
Okay. Item number 3, file number 13.
Oh, you know what? I'm sorry. I think since it's after 5, we should do public comment now, if that's okay.
Item 4.
Members of the Sunshine Ordinance Task Force, Ray Hartz, Director, San Francisco Open Government. I'd like to, since it's always quoted at me, read from page 131 of the Good Government Guide. Quasi-judicial bodies must afford a fair hearing to the parties before them. Central to a fair hearing is the principle that decision-makers come to the hearing with an open mind, prepared to hear both sides and to decide the case on the merits of the evidence presented and the governing law. I was at an EOT hearing last month and basically showed up with not the first, second, third, fourth, or fifth, but the 6th determination on the same subject. A letter from the clerk of the board saying she would not comply, and Mr. Caldera, who is the deputy clerk, saying that that was the case. They would not comply with the order. I want to acknowledge and commend 2 members of this task force, Mr. Oka and Mr. Highland, who did their best throughout the hearing to listen to the facts and make a decision based on the facts. And yet the ultimate decision that was trying to be forced by the chair, Mr. Pilpel, was to conclude the matter. You have a directive from this task force to a body, and the body says we won't comply, and you conclude the matter? What does that say for this task force if you won't even enforce your own rulings? And at one point, Mr. Pilpel actually said, well, some of us didn't agree with what the task force decided. And if you look at the vote on the particular case that was before them, he was one of 2 noes versus 7 ayes. So now it seems that if a member of this body is a chair of a committee and he doesn't like what the task force decided, he can simply choose to ignore it. One of the things that was brought up and was asked of the administrator is, did Mr. Hart submit any documentation? I thought to myself, be honest with you, why did I have to?
I'm sorry, is your 3 minutes is up?
No, I've got a timer here and it says 41 seconds left.
Okay, go on.
And Mr. Pilpel asked the administrator, did Mr. Hartz give any documents? I didn't think I had to. I had an order in hand and 2 refusals from the body to comply with the order. Why do I have to present evidence? And then we started re-adjudicating the case. At one point, Mr. Highland asked Mr. David, were you there for any of these cases, the 6 cases where we discussed this, because he was raising objections about the placement of the summaries. And he said no, and yet said, I didn't understand why it makes a difference.
Thank you. Is there any more public comment?
My favorite subject, the 6-vote rule. I don't know how many of you are familiar with the Supreme Court of California decision rendered yesterday in a case brought by the Sierra Club against Orange County for the database for its mapping system. What's important about the case is it came down in favor of the petitioner, and the strongest piece of its reasoning involved Proposition 59, which I'm sure you're all familiar with. It's a constitutional provision. And that provision requires that when a statute or other authority is being construed, If it favors public access, it is to be reviewed. If it involves public access, it's to be reviewed broadly. And if it restricts public access, it's to be reviewed narrowly. Now, what has that got to do with the 6-vote rule? If you remember, one of my memos, I raised this very question. The point is that neither Mr. Threet nor Mr. Owen, on whose memoranda you relied last year in adopting it, ever mentioned that section of the Constitution. And it's pretty important. The other thing is I want to point out on the 6-vote rule. I'll just read one paragraph because I don't know how much time I have.
How much time does he have left, Madam Administrator?
1 minute, 20 seconds.
Okay. You know, 2 of the seats are vacant. That means a complainant now has to get 2/3 of the vote in order to succeed. We know at least 1 of 2 of the members are prone to vote against a complainant just as a matter of habit, or they're absent, in which case it's a no vote. The effect of the 6-vote minimum is to turn on its head the burden imposed by both the CPRA and the Sunshine Ordinance on the officer or person withholding public records to justify the refusal to disclose those records. It does so by requiring the complainant to bear the burden that the record is not exempt from disclosure. And of course, more egregiously, the 6-vote rule requires in almost every case that a complainant must carry that burden by a supermajority vote. That's what we're talking about, and that's the problem. And if you check the records, you'll find there are a number of instances in which a complainant has gotten 5 votes, which would be a majority of 9, and yet lost. I don't want to talk any further about it. I think that's pretty obvious that it's the elephant in the room, and you're going to have to do something about it. And I don't think that it's fair to complainants to ask them, come up here, try to persuade you on something where they don't even have the burden of proof. Thank you.
Thank you. Is there any more public comment on items not on the agenda today?
Yeah, I'm just making a general public comment and not regarding the 2 matters before you today.
No, because we're not at that yet.
Right. I just want to make you aware that my street artist permit was revoked illegally on March 13th, 2013. A week before, I did a public record search, and I found that Howard Lazar filed a concurrent civil case at 400 McAllister Street, claiming I was stalking him. The case remained open for 3 months. I wasn't served, but I went to the court date nonetheless. I showed a videotape of a chance meeting in the Ferry Building where I was waiting in line in a coffee shop, and Lazar approached me. I said nothing, and he was mouthing off. He claimed he was not on city time, yet he filed as a civil servant. I just want to make you aware of that, and that I won an appeal by unanimous vote.
Great, thank you. Is there any more public comment on items not on the agenda?
Peter Warfield, Library Users Association. The list of seats of the Sunshine Ordinance Task Force that's on your agenda right now shows 2 vacancies. And so I certainly want to say that the issue, well, there are 3 vacancies, but 1 is ex officio, the not voting. So that underscores the issue of attendance as well as membership. You all may, wishing and even accomplishing perfect attendance, find yourselves in a situation where a member of the public has to get a real supermajority. Right now, with 2 people gone, that means there are 9 members maximum able to be present. And so to get 6 votes, that's what in electoral politics would be considered a landslide, a rarity. So even though today it looks like you have a full House of members, I count 9, to approve of anything, particularly with respect to a complaint, would take a 6-3 minimum vote. And that is a 2/3 majority of those present. And generally, that's considered almost insuperable in any kind of a normal democratic process. It's a supermajority that's rarely invoked, and for particular things such as raising money through bond measures and the like. So I think that the previous speaker, Alan Grossman, is quite right about that concern, and as somebody who's been at the Sunshine Task Force over and over again over the years, that's certainly a concern of mine. I actually had one time the loss of a quorum right after presentations had been made, and it was 6 people present and then 1 person left. But there are real problems with attendance as well as with filled or not filled vacancies. I wanted to just briefly say that there are very serious procedural issues here, whether you're sending proper notice to folks about when meetings are happening, how much time there is. I do note an improvement. The last letter that came to me with regard to a meeting came about 2 weeks early and gave about a week to provide material, and that's an improvement. But the whole mediation procedure, which is completely undocumented, I think is completely outlaw. And then there was a memo from the EOT chair as to what issues people should address for a hearing at that committee. Further, I'm very troubled by what I would call loaded questions like, show us your procedures, when in fact there's been no establishment that procedures were an issue.
So, I'm sorry, your time is up.
So I think you need to really look at your procedures here and how you carry them out. Thank you.
Thank you. Is there any more public comment?
Hi.
Hi.
Hi there. I'm Diane Carpio. It's my first public meeting, so I'd like to introduce myself because you'll probably see more of me. In January of this year, there was an incident. I have a complaint filed with the Office of Citizens Complaint, and I did go to 850 Bryant to request a copy of the police report, which I never received. I again filed a request for a copy of the police report 2.5 weeks ago, and my time's running up to file a complaint with the city, but I don't know what has been, I haven't seen a report, and I can't get one, and it seems that the system is designed to fail. You have to mail in a request and then with an envelope and wait. I haven't received any response from the records department, and so I'm forced to either file blind, where it could hinder a case that I do have, or not file at all. So in looking at your website, it was great. There's a lot more information on there in the last 6 months citywide for all departments. This particular case involves several concerning issues, and there's no easy, I'm trying to catch up on city policies and laws and regulations and how the whole system works, and it's been overwhelming. So, just would love to know when the next, if you guys put out a workshops for citizens to assist in the whole Sunshine Ordinance, and even the purpose of and what you handle and what you don't isn't quite clear. So if it's to assist citizens when they've gotten nowhere with other departments, then I need your help.
So have you, so just so I can be clear, you have not filed a complaint with our office? Sunshine Ordinance Task, you have not?
No, I didn't.
For documentation?
No, I filed it with the Office of Citizens Complaints, and a month and a half later, I was sent another report to fill out to send to the police department again for a copy of the record.
So you should send a request to us, and you can call our office and our administrator anytime, Andrea, to help you through the process, because you asked for documentation, which you did not receive. And that is what we do here. We try to help you get the documentation, that information. So you should call the Sunshine Task Force office, and the number is on the website, correct? Yeah, no, by heart.
Yeah, but the forms or the process isn't quite.
The complaint process. Andrew, do you want-
Excuse me, the number is 554-7724.
I appreciate that, but I don't have a,
So you
I got a lot on my mind remembering
so
that is.
Just go back to the website, the Sunshine Task, like you did.
Right.
And the process is there, but you can also just call the number that member Nee just gave you, and the number is there, and then someone will answer and call. Andrew's very responsible about helping. Say it
Okay,
again.
and just a quick question because my
It's on the agenda too. If you want to take one of the agendas for today, it has
I
the
will.
number.
Just expectation-wise, from filing to receiving real assistance, because it seems like
I don't want to interrupt you because I do want to be fair to everyone, and your time is up. So what I would do is just call our office tomorrow, and Madam Clerk, Andrea, or someone she'll answer every question through the process, how to go about it, what the length of time is, once you file a complaint to be heard and for us to move forward on it, and how the appropriate paperwork for you to fill out and stuff like that, just the whole process. So do that, because now you should come to us, since you have, it seems, jurisdiction for us, that we can help you try to, solve that. So definitely call tomorrow.
I appreciate that.
Okay, thank you so much. Is there any more public comment? Hold on. If not, I'm going to close public comment right now. Member Pilpel?
Yeah, I just had a follow-up. I'm sorry Mr. Grossman left. I was going to hand them out later, but I did bring copies for members of the task force and a few copies for members of the public of the Supreme Court decision in Sierra Club versus Superior Court regarding Orange County. It's a really interesting case about electronic records, and I encourage people to read it. So I'll do that when we get there.
Yeah, I'm going to leave it some for the members of the public out there, as well as for the members of the task force. Okay, Madam Clerk, can we go to the next item, please?
File number 13005, complaint filed by Paula Detesh against Arts Commission for allegedly failing to respond to an immediate disclosure request for records pertaining to the operations of the Arts Commission.
Okay, we need to determine jurisdiction. I believe both parties have accepted that jurisdiction have accepted jurisdiction. You have, and...
Excuse me, Madam Chair, I believe we still need to vote on it.
Yeah, no, I just wanted to ask them if both of them have agreed about jurisdiction.
Okay.
Yes, I know. And Mr., I'm sorry, the Arts Commission, Mr. Lazar, okay. So have you agreed about the jurisdiction?
Absolutely.
Okay, great. So you can sit down for 1 second, Paula, until we make the vote about jurisdiction. So knowing that both parties have accepted jurisdiction, I'd like to see if someone would move that jurisdiction is accepted.
So moved.
Do I have a second? Oh, thank you. Is there any public comment about jurisdiction? Do any members have any issues with the jurisdiction? If not, I'd like to declare this motion for jurisdiction passed without objection and move forward to the content. And I'd like to invite Mr. Tesh to come up, and you have 5 minutes to tell us about your case and the substance.
This is a case that is pretty typical of the non-relationship I have with the San Francisco Arts Commission. It's been years and years of no personal contact, long-winded, off-topic emails that come weeks late from Howard Lazar over simple matters like, how do I renew a permit? Can I get an appointment? Because I've been in there about 7 times and nobody's been in your office. And I've spoken about it at the Full Arts Commission many times, asking them to please intervene. I'm constantly met with slander and allegations of harassment and stalking, which don't take place. That's their defense towards everything. So this was done completely by email, and my reasons for it were to try and simply get some information. Because I had been out of California for about 7 years, there was a civil grand jury report. There were a lot of changes with the Arts Commission. And when I came back, I actually went out of my way and spoke with Rebecca Krill personally and explained to her my reticence about even applying for this permit. And I had her personal assurance that she would manage Lazar, which of course didn't happen. So I just filed this thing out of curiosity on February 7th by email. I asked a couple questions which were not answered. They weren't even addressed in their response, and it's pretty clear and obvious to me. I'm referring to the memorandum of June 4th by the City Attorney's Office, which is kind of a summary of what an objective person came to the conclusion of. And he says on the first page that after some research, it appears that Lazar did not provide the requested information. And then there was the claim that Lazar received as much as 5 separate requests a day from me. That did not happen. You would see them coming through the pipeline if that were true. This particular request before you was misplaced and unanswered. That's a typical excuse of theirs. I went through to the letter of the law. I sent the email. I got nothing. I contacted Paula Jessen after 10 or 16 days. She attempted to arbitrate, and the claim is always the same. She has bogus emails. She has many emails. I don't know her email. I've had the same email for 30 years. It's sandbagging, which is typically what happens in that entity. So I just made a couple questions, and they were not answered. Some of them were answered in a very generic, broad manner. One, they even made light of, claiming that I was asking for a verifiable reason as to why no one was there at 2 a.m. on February. All they had to do was read it. It's 2 p.m. on February. That was Paula Jensen, who again went out of her way to get an email appointment so that I could go in there. Simple thing of renewing a permit. It takes less than 5 minutes to do. I had been there 6 times, and no one was there. I'm sorry, there are no cameras in that place, but their counterclaim as to why no one was there at that time was that they were there. Something is wrong here. The last part of my request is a statement made by Lazar at the beginning of a public meeting, a particular one saying, don't engage her. They didn't even respond to that request. So the normal way these type of requests go is that you wait a reasonable period of time. After no response, then you might file a form in the clerk's office, and then you might try to contact Paula Jessen. I did my due diligence. And in my opinion, these questions were not answered. They were clear and specific questions that came, some were generic that really didn't even speak to the issue. And then they always throw in their typical harassing things. I'm referring to number 6, a reason why no one picks up the phone during business hours. Well, their response is that they believe that I'm the one who's calling and harassing them. Well, where's the evidence of this?
Mr. Tesh, your time is up. So thank you very much.
Okay.
Are there any members of the public that want to support Mr. Tesh with any facts or evidence? If not, I'd like to invite Mr. Lazar up, and you two have 5 minutes. Tell us about the case.
Thank you, members. I'm Howard Lazar, Street Artist Program Director for the San Francisco Arts Commission, and I'm referring you to a letter of March 18th, 2013 that we sent you, and we freely admitted our mistake. We're not denying that. We misplaced it. That's not a lie. We misplaced it. And yes, there were days when we'd get as many as 5 emails a day from her. okay? Now, I did not do a count as to the number of requests that she sent me that I answered, but I do have those files back in the office, and they're quite lengthy. In this letter that I'm mentioning to you, we did, while we failed to respond to her on time, we were with this letter responding to every one of those questions. And I won't read the whole thing to you, you have it, but I do want to highlight certain things. She was requesting a breakdown of my duties and the hours allotted for each task, and so we've included the detailed job description for me, and we stated that we don't have a breakdown of the duties that I performed during those hours. She was requesting a breakdown in the duties that I perform for another area of the Art Commission, and we have flat out stated that I don't perform any duties on behalf of the Art Commission that fall outside of my job description. She requested a breakdown of duties of my assistant, Alyssa Likouris, and we have attached the job description there. She mentioned, she said she requests any and all records relating to timesheets of both employees. We provided all the timesheets for both the employees and their official job descriptions. She then was talking about requesting a verifiable reason for no one picking up both the phone during business hours and any all records relating to this, which she just mentioned. And we've stated in this letter that our offices are open from 9 to noon and 1 to 4. And during this time, we regularly answer phone calls. However, in recent months, up to that point, we stopped answering the calls because we had experience prior to that of her incessantly calling us, and so therefore we made the statement, we believe they were from Mr. Tesh, and they had been of a harassing nature. And also, my own director, Tom DeCaney, instructed me not to pick up the phone, just answer the messages afterwards. Typically, many of the calls she made, she wouldn't leave a message. Okay, those who want information, leave a message. She then was saying that no staff member was in the office at 2 a.m. Well, of course no one was in the office at 2 a.m. Perhaps that was a misspelling on her part. But there was one point where Rebecca Krell had made an arrangement for her to come in on February 4th at 2 p.m. to pick up the guidelines she requested, and my assistant and I waited and waited, and she didn't show up, and we waited for half an hour. She missed the meeting, and perhaps she got the time wrong. I don't know. Then she was referring to records regarding a statement I made at one of our screenings of our advisory committee, and the email she sent predates the February meeting that she was talking about. Therefore, we believe the meeting in question that she was talking about took place on January 12th. And so we attached the minutes to the meeting. Certainly our audio recordings of the meeting are always available. So we are totally upfront with this. We don't have anything to hide with this. We can only say we are sorry that we didn't fulfill this particular request on time.
Thank you.
Yeah.
Are there any members of the public to support the Arts Commission with any additional facts or evidence? If not, I'd like to invite Mr. Tesh up for a rebuttal, and you have up to...
Point of order, Madam Chair. At this time, I believe this is when the task force would ask any questions of the complainant or the respondent.
I'm sorry. I'd like to open up to the task force for any questions or concerns. Member Pilpel?
Thank you. To Ms. Datesh, there's reference in the packet to your original email dated February 7th. I've gone through the packet material several times carefully. I don't see that email. Was that actually provided to us?
It was. I actually went in last week and copied the entire file. That's why I'm looking at it.
Can you tell me where I can find that?
It was in the file. I asked them to copy the entire file. And actually, there was no typo. It's clearly here. It was February 6th at 2. p.m. So, there's really no conversation between me and Lazar.
All I'm asking is where that original email is. Can someone help me with that?
It's in the
Did
file.
anyone see it?
I copied it.
No. Okay.
I don't see it.
Okay.
It's in here, too.
Oh, from February 7th?
Yeah, that's what I'm looking for. Anybody?
IDR. It's on, well, I'm looking on my computer, so it's the page 14, maybe, of 121. Do you see that? I see it, it's page 14.
For me, it's the second page when I copied the packet.
Yeah, it's page 14 of the electronic copy.
What's near it?
It's right, it's at the end of,
Oh, I'm sorry. I found it. You're right. Page
Yeah.
61 of the full packet. Okay, there it is. Immediate disclosure request, February 7th. Okay, I got that. Thank you very much. So I guess what I heard is that the Arts Commission concedes that it was late, but they're not conceding that the information was not provided. So I guess I'm leaning towards a finding of an untimely response, but it does appear that they answered the questions and provided documents. You may not be satisfied with the answers.
They did not.
Okay. Well, they provided some documents, and they did provide some answers, and it appears to me that they answered questions that they weren't actually required to answer, but they did. So that's
I'm
just where
sorry.
I am.
I went through the proper request. If they took it step by step, paragraph by paragraph, and actually read my request and responded to them, we wouldn't be here today. Just a simple thing like completely ignoring a complete paragraph or changing the wording. I mean, one questions what is going on over there. I'm referring to the last paragraph. I request records relating to a particular statement. If they didn't have the records, they should have stated, we don't have the records. That's the requirement of the Sunshine Law. I don't remember the exact section, but it's a disclosure section that relates to public documents. You see, I'm requesting specific information. If they cannot provide the information, if they cannot even read the statement, well, there's a problem here. And then in addition, in the response, they want to place allegations on me, which are vague and always speak to harassment and stalking. We don't know what they're talking about. We don't even need to know. This is irrelevant to a record or information request. The last time I was before you, that was their response. I mean, I'm not thick-skinned. It's only over time that, you come to understand this is the way things go.
I don't have any further questions for Ms. Datesh. I do note in the packet that there were at least 2 emails with Ms. Krell confirming Monday, February 4th at 2 p.m., and then the subsequent comment from Ms. Datesh was related to February 6th, so it does appear.
There were 2 appointments. One
I'm
to
sorry,
pick up.
I'm not asking a
I'm
question
sorry.
at the present time, so I just wanted to note that for the task force. So that's just where I am on this. Thank you.
Great. Member Nee?
Yes, Ms. Datesh. If you could give us specifics,
Yes.
what requested information is still, do you still await or is being withheld?
My question or information is not generic timesheets. He hasn't given job.
What information did you request that has not been given, that has not been provided?
Job description of both him and his assistant, particularly the amount of time the assistant spends on other duties, because that was a huge issue at a hearing. There was a fee increase, and people were upset and wanted to know, well, where is the money of these permit holders' fees actually going to? I wanted to know particularly about a breakdown of what he does with his time, what amount of time is devoted to this task and this task, what that type of thing.
Ms. Datesh, I guess kind of I'm sorry.
Member Nee, did she finish answering your question?
Well, yes, yes and no. There is some information that I see has been provided.
Yeah.
And I'm trying to find which page it's on. I had it a second ago, but it looks to me that Mr. Lazar or somebody else within that office has provided job descriptions both for Mr. Lazar, without giving specific hour-by-hour breakdowns of what they do, but the job descriptions for Mr. Lazar and Ms. Licouris have been provided. Those you don't find those?
I'm referring to the original email that I wrote. I request a breakdown of the duties performed by Licouris, unanswered. I request a breakdown for the duties performed by Lazar, unanswered.
You don't think that a job description is
a generic job description?
Job description of what he does?
No, you have to look at the context of an illegal or a fee increase that was slipped in not through the street artist level, but at a last minute, not even giving 72-hour notice agendized.
I'm sorry, let me just interrupt you for a second. I'm sorry, Paula, just 1 second. What does that have to do with the job description? You requested in your February 4th letter, you asked for a job, the job duties. A job description was given to you with a timesheet or
a generic time that somebody's just signed off on, because you have to look at the history of this. Mike Addario was before you a number of years ago and basically asked for the same thing. I wasn't here, but in the minutes, he was questioned by your former chair, Hope Johnson, and he said these papers have been altered. So there's, all kind of questions that people have, particularly when a fee increase has been slipped in on the side. There were like 100 angry people who wanted to know what this man does. What does the assistant do? Where is their money going? The burden isn't on me to ask this, to get answers for this. I just simply am standing before you today saying, here's an email. According to your code, there's a way of requesting information, which I followed to the letter. They did not reply in a timely fashion. The email is lost like everything else. If they went through this email step by step and said, we don't have that information, we defer you elsewhere, we can't answer this question, but we will provide you with generic something or other that's just going to fill it. I'm referring to this 2 paragraphs from the bottom. I request a reason why no one's been in your front desk at 2 p.m. on a Wednesday when I had a confirmed appointment through the city attorney's office that says 2 p.m., not a.m. Yet they want to turn it into something else. There's no margin for dispute here. This is written. It's not
I'm
verbal.
sorry, just to clarify.
I'm sorry.
Didn't they say that they waited for you for that meeting at 2 p.m.? That they were there?
Chair Grant, there were 2 meetings. One, which takes less than a minute to process a street artist permit. Takes less than a minute.
Were they there and were you there? You guys made an appointment. Were you there?
I was there.
And
they
he
were
was not there.
No one
is
was
what
there.
You're saying.
You can call Paula Jessen because I left a message with her verifying this. There are no cameras there. I want to tell you that.
I think that's what. Member Nee, I just want to go back to you, make sure you're getting your questions answered.
Mr. Lazar, please. Mr. Lazar, I have in front of me, and I guess maybe they're not in front of you, but they are starting on pages 123 and 141, not 141, 140 of our packet. On page 123 of our packet lists the duties of the Street Artist Program Director, which I believe is yourself.
Correct.
And on page 140, the Street Artist Program Assistant, which I believe would be Ms. Licouris, is that correct?
Correct.
Okay, now, to whom do you answer, sir? Who is your immediate supervisor?
My immediate supervisor is the Deputy Director, Rebecca Krell.
Okay, now, let's say for discussion's sake, Ms. Krell sends you a memo or calls you up and says, I want to find out how much time you spent doing each of these various and sundry things. I want a list of what you do, how much time you spend supervising the street artist program assistant. I want a list of the hours you spend preparing and issuing an annual report to the controller. I want to, if she asked, do you keep track of those kinds of things?
No.
You don't?
I would have to go back to those files and try to remember how much time I worked on the annual report. I do keep track in terms of my own hours on sunshine requests. That I do, and I report that to the commission.
Okay. But you don't really, and you're not asked to keep a running account of the hours you spent on various and sundry individual duties?
No, sir, I'm not. However, when I'm out in the field on monitoring assignments, I follow basically what the police officers have shown me. I keep a logbook that will detail the time I'm at a certain street corner, checking a certain number of licenses and the names of those people.
Okay.
And so on. You know, the next, I turn the block, there's another time, and so on. That's about the most accurate I keep in terms of that particular duty. But other duties, like you read right there, well, you know, I mean, supervising an assistant, if I'm there in the office, it's an ongoing thing.
Okay.
Yeah.
Ms. Detesh, please. You've heard the explanation given by Mr. Lazar. Have you asked for a logbook of how much time he spends in the field?
This is a matter for the, no, not in this complaint.
Okay.
No, I haven't.
Thank you.
No.
Are there any more questions from the task force members? If not, then I would like to ask Ms. Detesh to come up for final statement or rebuttal.
Pardon me. Respondent first.
Oh, I'm sorry, the respondent. Forgive me, I just got off a plane. Mr. Lazar, if you have 3 minutes, if you want to have any rebuttal or final comments you'd like us to consider.
I don't know what to say that I haven't already said and provided. She brings up a lot of extraneous events and issues that are not part of this particular case. And I know you're not looking for responses to that. So I've given you all that I have. I hope I've explained to you that I don't keep a running logbook as to how much time I spend for each duty. Other than if you looked at my logbook of a particular afternoon, you could see, you know, monitored Fisherman's Wharf, 2 o'clock to 3 o'clock, something like that, you know, and then you could total all that up and figure out the percentage of that in an 8-hour day, you know, something like that. But I've never had to do that. So I really can't add anything more.
Okay.
Thank you.
Thank you. Mr. Tesh?
I think Lazar brings in a lot of extraneous issues. You can see it in almost everything he does, even in his response or accusations, which are off topic and irrelevant. I am sticking to the original email where I asked clear and specific questions. Paragraphs were completely ignored, and if he didn't have an answer, all he had to say was, we don't have an answer to this question. So it's not a question of what does this man do on his little walking journeys throughout the city. It's a question of a more broad thing. I asked clear and specific questions in a timely fashion. They didn't answer it. It was ignored, lost, which is typical of them. Extraneous complaints were thrown in, and he's thrown them in as some kind of weird defense today. And really, I got some filler and, some generic timesheets, but it doesn't speak to why they don't pick up the phone. They haven't picked up the phone in 35 years. It's it's nothing new. It's almost impossible to do business with them. And I'm not the only one who says it. Job description could have been good. Job qualifications in your withholding requirements. Job qualifications don't need to be withheld. The person's schooling can be disclosed in a timely fashion. This was just hastily put together, like most of what they do, full of nonsense. 2 p.m. is clearly stated, yet they want to go off on a rant about 2 a.m. All right, well, they didn't answer the question. And in my view, they have not complied.
Okay.
Thank you.
Thank you. Did you have a question?
No.
Okay. I would like to open it up to the task force to see if anyone has found, if there's a motion to find a violation of the Sunshine Ordinance.
Go ahead.
Member Pilpel?
I would so move to find a violation of 67.21 for failure to timely respond. That's all I'm finding so far. I'm open to changing that, based on discussion, but that's where I am.
Member Nee?
Well, if there's I will second for discussion purposes. I would suggest, I'm not so sure actually about 6721. Although, I'm certainly open to it, but I'm thinking violation of 67.25A and 67.29-7, which has to do with record keeping in a professional and business-like manner.
You said 67.21A.
67.25A.
25A.
And 67.29-7. And if, I'm not ruling out 67.21, I believe it would be B, for B as in Bravo. I'm not ruling that out. I think it's, we can bat this back and forth among us.
And if I might.
Oh, Member Pilpel?
I'm with the 21A. It was an immediate disclosure request.
Yeah.
So, yeah, I'm
25A.
25A.
Yeah, excuse me, 25A.
Okay.
21B, as in Bravo, yes. But I'm not sure that I'm with 29-7. I don't know that that was specifically alleged, and I'm not convinced that there is some overall lack of clarity there to their record keeping.
Well, Madam Chair, through the chair, the respondent did, I believe, admit there was misplacement of email, and I really am mystified as to how one misplaces an email. Maybe a copy, maybe a printed copy thereof, but I'm really having trouble figuring out how somebody misplaces an email, the actual email.
Maybe they worked on it. I think that speaks more to policy and procedures, but I don't know that it speaks to record keeping necessarily. I think that's something for compliance to sort out.
Procedures don't go to record keeping. Doesn't go to procedures.
Again, I think that's something for the committee to explore if we find a violation.
No,
There will be.
not yet. Yeah, there will be, so I'll call for it. So do you want to amend your...
I'm happy to amend to add 25A. I'm not inclined to add 29-7 right now.
Madam Chair?
Member Nate?
Why don't we, perhaps we should move for separation then of 6729-7?
Yeah, we can do two separate
We can make that as a
votes.
separate motion.
Yeah. So let's take your motion first, which,
Fine.
so can you, just so Madam Administrator can follow along, what exactly is your motion?
It's to find a violation of 67.21B and 67.25A
Okay.
for failure to timely respond to an immediate disclosure request and a records request.
Very great. Okay, do I have a second? Did you second?
I believe I second.
Okay, with the addition. Okay, so we have it's been moved and seconded. I would like to open it up to public comment on the immediate disclosure request issue for this? Does anyone have any public comment on this? Hi. So this is public comment specifically on the fact,
matter,
on
yes.
this matter and on this issue about the immediate disclosure request that he did not respond, the Arts Commission, in a timely manner.
Right.
So, on this particular case.
I have watched this committee on sf.gov, so thank you for putting it out there, because it really helps people who can't get here. And I
don't think the audio, you haven't seen us, because our committee is not on.
Or maybe it was
SF.gov.
different, maybe
It's
it was
probably
the Arts
different.
Commission or
Something else,
something
yeah,
else.
just so you.
But the complainant, I feel for her. The issue of receiving no response and then bare minimum response, bare minimum requirements that don't really address a request for information is protocol. And the rhetoric that is used throughout San Francisco in every venue, private, public entities, is just exhausting when somebody's looking to get help and then people in charge just kind of give the bare minimum, don't address the specific issues at hand, try to blame or bring other things into it. So I applaud you at finding an untimely response out of all of this. I know this has been going on for a while, and I appreciate the complainant for keeping up her strong will. We need it.
Okay, thank you. Is there any more public comment on this particular issue?
Peter Warfield, I'm not a party to this, and I'm not familiar with it, but I did want to ask, if you don't have a motion on 67.29-7, will there be an opportunity for public comment on that?
We're just voting and talking about this issue right now. That's not to say that we are not going to put forward another motion on 67.29. We're going to do this, and then we're going to see if...
I appreciate that, but if you don't have a motion on the other item, if there'll still be public comment.
There'll still be public comment,
Thank you.
exactly. Any more public comment on this particular issue? If not, I would like to take this to a vote. Madam Administrator, I'd like to do a roll call vote.
Okay. Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Pilpel?
Aye.
Pilpel, aye. Member Sims?
Aye.
Sims, aye. Member David?
Aye.
David, aye. Member Highland? Highland, aye. Member Oka?
Aye.
Oka, aye. Member Fisher?
Aye.
Fisher, aye. And Chair Grant?
Aye.
You have 9 ayes.
Madam Chair?
Member Nee?
Yes, I move to find violation of section 67.29-7.
Do I have a second? It's been moved and seconded for violation 67.29-7. If anyone has any questions about that, I'd like to open that up. Member Oka seconded, right? Yes, thank you. Okay, so I'd like to open that up for any discussion. Member, is that a question?
Yeah, I'm just
Member Washburn.
wanting to hear more from Member Nee about his reasoning behind this. So we have whether this is records maintenance or a procedural issue. So and whether if it's a procedural problem, does that fall under 67.29-7? So I know that we're looking at emails, and the emails, I think there wasn't the case where the emails were deleted. They just weren't monitored. The procedure wasn't monitored.
Well, I think that's why we need to find that, there was a failure on the part of the office to maintain public records in a professional, business-like manner. When you lose something like an email, that to me says there's something less than satisfactory in their methods of record keeping.
So this seems, is this like the matter in the David Campos office where we were finding they weren't responding in a timely manner because their procedures weren't in place? Is this analogous to that, or is this something different? I'm just thinking that if it is the same, we should try to be on the same page here.
Yeah, I haven't really drawn that connection one way or the other. It's possible that it's there, but, I was just looking at this issue separate and distinctly on its own. Maybe there is a, maybe the two are related, but I was just looking at this issue, by itself.
Okay.
Attorney 3, did you have something you wanted to add to this?
Through the chair, certainly an argument could be made that maintenance of, in a professional and business-like manner of email could be required by this provision. However, there are also other requirements in the provision that apply here, and I would suggest that the task force consider whether those requirements are met. There are a number of provisions in the ordinance that have higher standards for certain parties in the city or certain officials, and this particular one is one of those. It says it applies to the mayor and all department heads, and there's a special call out of mayor and department heads because there's a special sensitivity to maintaining and preserving the records of those particular officials in the city.
Particularly relative to transition of department heads.
Can you speak in the microphone so we can understand?
I'm sorry, particularly with respect to transition of officials. I would also just comment that we know that there are certain individuals who are displeased with the Arts Commission generally, or the Street Artist Program in particular, but I don't know that we have specific evidence before us on this case or more broadly that there is a pattern and practice of them not responding. I think we certainly have individual instances, but I'm certainly not persuaded that there is general disarray. You may disagree and find otherwise, but that's
Member Oka?
that enough.
Excuse me. Based on my reading of Ms. Dietrich's email and specific requests, she made some specific requests relevant to the job description, and I don't think providing a generic job description fulfills that request. I think if somebody requests specific duties of a staff person's job, and that is public record, that is open to public record requests, I think that should be provided, and it appears to me quite clearly that this was not done.
So, Member Oka, just out of clarification, because when I look at what she requested, the Street Artist Program, the director and the assistant, there it's bullet points of specific duties of each of these individuals, and that was provided to her. So that's where, and I don't find it to be generic, I find it to be the duties of the person that she requested the information for, and that's in our packet. So what else, what level of duties? I just want to be clear so that, if there was more that she wanted, then, they didn't, fulfill that. But when I look at the documentation that was provided to us, it seems like they did fulfill that request. Maybe they didn't fulfill some other things, but they did fulfill that particular request.
Not a generic 1840.
Yeah, it's not generic. I don't find that. I think that might be a little bit, for me personally. You find it to be generic?
Yeah.
Okay. Member Nee.
Yeah, Madam Chair, through the chair, I wanted to get a clarification from Attorney 3, and I just want to make sure that I'm clear on what Mr. Threet said regarding the 67.29-7 question. And maybe what I heard, maybe what I didn't hear, is that 67.29-7 sets certain standards for the mayor and department heads, but that perhaps people not at that level should not be held to that particular standard. Maybe I misheard, and I'd like a clarification for Mr. Threet.
Through the chair to Member Nee, my statement was that the provision applies specifically to the mayor and department heads, and therefore it does not apply to folks who are not mayor and department heads.
Thank you.
Member David?
I guess I'm also wondering, an issue that comes up quite a bit is that if a document does not exist, it does not need to be created. So I guess my question would be that whether or not we find the job description adequate or not, is it incumbent upon the department to create a document that better describes the job description if it did not exist already?
Member Nee.
In light of Mr. Threet's comments, if the second accepts, I will withdraw my motion to find violation of 67.29-7.
Member Oka? You seconded Member Nee's, right? He's withdrawn. If you're in acceptance, he'd like to withdraw that in light of.
Accepted.
Okay. So that motion has been withdrawn. So it's off the table. So we need to vote on. We did that already. Okay. So I'd like to. So there's nothing to talk about as far as that. I'd like to open it up to public comment on.
We did public comment and found a violation. Unless there's a further motion, then we take no further action and don't need to take further public comment.
Okay.
I would suggest, but then you need to decide where to send it.
Attorney Threet?
Through the chair, although I agree with Member Pilpel that that's the general procedure, I believe the chair did assure at least one member of the public there would be additional public comment.
Yes.
Fair enough.
If this motion was withdrawn. So that's why I'm offering that opportunity.
Members of the Task Force, Ray Hartz, Director, San Francisco Open Government. I'm disappointed that Mr. Nee has removed this because I look at it as a dog ate my homework excuse. The bottom line is this section may apply to the city department heads, but the department heads have a legal responsibility to ensure that everyone under their supervision follows the law. And you can't simply point at the department head and say if the department head doesn't do it, everybody else is off the hook, because that basically leaves everybody off the hook. The simple fact is, if a proper record keeping had been in place, they would have responded on a timely basis, and this whole hearing would have been unnecessary. They admitted publicly that they did not, in this case, do it. I disagree with Member Pilpel, who seems to feel we have to have some sort of a proof of this is a widespread problem that they do again and again and again. And there's no reason any complainant should be under a burden of proof of having to prove that not only did they do it in the case before you, but they did it in other cases. Bottom line is, she put in a request, they lost it. That's bad record keeping. And the question is, do they need to be given notice that that is inappropriate? And that's why I felt Member Nee's motion was appropriate, to let them know that in this case, the reason you violated the law was because your record keeping was lacking. And if you had kept your record keeping appropriately, then you probably wouldn't have been found in violation, because you probably would have responded on time. And again, I don't think there's any possible reason to hold the complainants having to come up here and say, well, it wasn't just this case, they do this all the time, or anything else. That burden of proof is totally unacceptable. It was their responsibility to do it. The responsibility lies with the department head to ensure that all members of their staff follow the law. In this case, they did not follow the law. They violated the law, and the reason they violated the law was because they lost their request. And they want to use that, it's like, oh, well, it doesn't matter that we didn't keep proper records. We have another case coming up, one of mine, where this is an issue also. So basically, I think this should be found as a violation because they obviously have publicly admitted we lost the email. And the reason we didn't respond is because we didn't maintain the records properly. If we had, we could have responded accordingly.
Thank you. Any more public comment on this issue?
Peter Warfield, again, I'm not a party to this and I'm not very familiar with this, but I'm very troubled by two things that were said here. I am disappointed that Member Nee and Member Oka have withdrawn this. I was going to say that Member Nee's question was excellent. How do you misplace an email? And I was going to make a little joke and say, well, technically, the dog ate it. So the first thing I have to say is to say that something was misplaced, I think certainly the older, longer serving members know that this task force has every ability and right to question. And so I think you need to ask. I believe the relevant description from the Arts Commission on page 119, this particular request was misplaced and was not answered. Rather than speculating on what that means, did the dog eat it or did the computer catch fire and blow up, you need to ask exactly what happened so that you will know the truth, or at least try. I don't accept the dog ate it or we misplaced it. These are typically excuses that are, at the very best, questionable. They're certainly questionable when there's any question of whether an agency wants to respond to something, and I think you have every right to ask the agency what exactly happened. And that'll also save you a lot of speculation about, was it their procedures, or was it somebody's oversight, or was it the dog ate it, or somebody made a photocopy or printed a thing. It can get very complicated, but at least you'll have some basis in fact rather than speculation. I'm also very much troubled, Gesundheit, by a member's comment about this being like the Campos case, lacking appropriate procedures. I've been going to many meetings and have had and seen a lot of correspondence about Library Users Association case with Supervisor Campos. And I'm not clear, and I'd certainly like the member to explain, when was it established that Supervisor Campos's violations of the law with respect to our case, when was it established and how that was because of a lack of procedures? Maybe it was something else entirely, and that was never established.
Thank you. Your time is up,
The
sir.
questions need to be asked.
Thank you. Are you speaking on public comment on this issue on 67 on the motion that was withdrawn?
Right, about the business matter, or business handling. Sorry, I'm Diane Carpio, resident, City and County of San Francisco. Not a party to the case, but have seen snippets here and there. And just would like to say that it happens, you do lose an email, but the last speaker was correct in establishing, not pointing blame or trying to figure out if the dog ate it or if somebody went out on maternity leave or nobody just answered it because they didn't want to answer it or they didn't have what they felt they needed to respond to it. And the job descriptions, they're all generic. We know that. I think what the complainant, and I may be speaking out of context here, but as a person who has no political experience, maybe requesting a performance evaluation where people say, I've done this, I've done this, I've done this, I've done this. This is where your taxpayer dollars are going versus here's my job description, bullet point, bullet point, bullet point. That doesn't tell you, how many hours or how much time you put on the street and into a report into making the city and the permit process better for the Arts Commission. It doesn't tell them how much time somebody is answering the phone. That information could give the public a better idea, and this commission a better idea of whether they're even funded appropriately to maintain an office to keep the phones answered and the emails answered. So that's all I have to say about that. Thank you.
Great, thank you. Is there any more public comment? If not, I'm going to close public comment on this issue. And let's take the vote. What is the task? Can we keep going, or do you want to take a break right now?
I'd like to request a 5-minute recess.
Okay.
Can you determine where you're going to refer this matter?
Oh, yeah. So, and back to the motion that we did all vote on, I'm going to refer this to EOT because this, as in the memo that was provided from the Arts Commission, Mr. Lazar did acknowledge that they lost or misplaced it or whatever happened with that document, but they did attempt to answer to the best of their ability. I want to refer to EOT because I think that perhaps you can work with that department to determine.
EOT.
Yeah, I'm going to send to EOT. To determine what perhaps procedures that they might be able to put in place so that, this won't happen in the future. But I'd love to really see if you guys could come up with some solutions to maybe help, the department do something better. Okay. Let's take a 5-minute break at 6:25. We'll come back at 6:30, and then we will take up with file number 13011. Okay, thanks.
What? No, I swear, I have no idea where it is on the website. I searched.
Find it now?
No, show me where
Look.
it is. Because I'm I searched and searched. And all I kept coming up with was the agenda.
Watch.
Trying to get it sent to her.
I know, it's like, Well, no, because, I was like, because what are we complying? Because it's basically, you know what I mean? Okay, San Francisco Gov. Okay,
That is what I did. I read half of it.
Yeah, so you didn't read the whole thing. I said, and then you get to the thing or whatever.
Gotcha. That's what I was like.
Yeah,
I kept,
that's what I was
I kept getting to the freaking.
and you're like, that's just,
yeah.
Yeah, it's a hyperlink. Excellent job. Andrew did an excellent job writing.
Is this a bathroom or is this just a door right here?
This side's open. There's a bathroom back there.
Lock the door.
Not today.
Not today. I was running. I was late. Hush Zill.
Always. Oh.
There, look.
Oh. Ah.
The bathroom right there? There's a bathroom.
Thank
I'll wait till you come back. Leave it open, I'll move to the bathroom.
I was in LA.
Do you still like when you go down there, you're like,
No, I'm checking into my flight tomorrow.
Hey. So have you been down there?
Yeah.
That's where you are?
Mm-hmm.
Okay.
Loving it.
Do you? Yes. That's good.
How do you know of it?
Did you still find an apartment?
Yeah, we live in Hollywood.
Where?
Yeah.
West Hollywood?
No.
Okay.
Yeah.
My friend Tanika lives, I guess it's West Hollywood. She lives more like Melrose, like.
Oh, she's like for real west.
Like, but you know what I mean? But like the end part of Melrose.
Oh yeah.
The nice part, not that cheesy part anymore.
It's expensive.
It's so, I just came up from New York. My ticket, do you know my ticket total?
It's crazy.
Yeah, but now it should be cheaper though.
No. It's cheap. It's expensive. I flew in Monday.
Oh, that's
Today.
why, yeah. Was it like $300?
No, it was 220.
Oh, that's not that bad.
But usually it's like 100.
Like 100.
I've gotten like 100.
On what airline?
And like 12.
112 round trip?
Mm-hmm. So like,
Are you serious?
yeah.
Where are you working?
I'm still working with my old firm. I was looking, but I'm like making so much money working with my old firm. I'm just like,
Stay there and keep doing it.
I know. They're gonna,
Please forgive me. I'm like jet lagged. That's why I was like, I appreciate. I said, please forgive me. I'm a little jet lagged. But I appreciate you. Like, you're like, no, point of order. I'm like, okay, yes, I'm tired today. Let's go flying. Thank you. Thank you.
Have the Koch brothers made a tender offer yet for current TV?
Now, come on, Al Jazeera.
Oh.
You know, yeah, exactly. They'll be like, current what? Current who? They're like, Al Jazeera. Well, Al Jazeera. I'm going to start my new thing. That's why I flew out to New York, because I knew I'd come back, and I'm still going to be here, but. And Soledad. So Soledad signed on. Soledad signed on to Al Jazeera. Soledad O'Brien signed on to the show that I'm working on. I knew she was, because she's not, because CNN let her go. So
CNN let her go?
Yep. So Soledad O'Brien is now working on the show. I'm going to be working on It's America Tonight. You're like shocked. I was. So now it gives a little bit more. You know what I mean? So we'll see what happens.
I tell you what,
This show, it's gonna. Well, I'll know by the next meeting. It's not gonna come on until September, but it's called America Tonight, and it's nightly. It's gonna come on at 9 p.m. Wait, it might be 6 p.m. here, like 9 p.m. I'll get all the information though, because I haven't gotten over there yet. But next Monday I'll know. But they just announced Soledad signed on. So, and she's going to be doing this hour-long documentary. So, now people are like, oh, wait a minute, because it gives, like, oh. So, see. What, CNN? Because Jeff Zucker now is at CNN, and he wanted to bring in a whole new morning crew, so he brought over, Chris Cuomo, and this other girl, I don't know who this woman was, but he's trying to just make, like, a whole new, CNN.
So what are you going to be doing?
I don't like CNN.
Either it sucks. But you know what? They're bringing back Crossfire.
That's what I heard, yeah.
Van Jones is going to be on it with
Yes.
Newt Gingrich,
It's gonna
Stephanie
be crazy.
Cutter, from Obama's administration.
Stephanie Cutter and Van Jones against.
And S.E. Cupp.
Oh, yeah. Yeah,
Is-
she's
so it's
been on
two
MSNBC.
She's on top 5 at 5 or 5, whatever that
No,
show.
it's called The Cycle.
The Cycle,
Yeah.
yes.
It was
Oh, 5 at 5 is on 5.
SC and, yeah.
Oh.
No, she wasn't on there.
Yeah, so she's leaving MSNBC to go to CNN. So
Stuff like that, they could put it on Wide World Sports.
yeah, it's going to be crazy.
But who's leaving MSNBC?
S.E. Cupp. So from that,
She was-
what's it called? The Cycle. But I mean, she's going to get, come on, she's paired like with Newt
Chilly in
Gingrich.
here.
And Van Jones loves to talk, So this is going to be, it'll be interesting, right? Oh, it's time.
I like Stephanie Cutter. She's good.
She's good. So it's going to be interesting. Okay.
CNN's been doing live telecasts of the Zimmerman trial.
Yeah, because the ratings have been ridiculous. So headline news, and now CNN is starting to do it.
SNBC's covering it a lot.
Time, right?
Actually, some of that's pretty interesting. When
I
they,
think it's
You
riveting.
see it.
I just-
It's something. I think he's going to get off.
from what I've,
I'm really worried that he's going to get off.
He's going to get off.
well, I think at the most they'll give him manslaughter. I don't think they're going to
Get him
nail
on.
him with murder. But
What is the charge? What's he charged first?
No, second degree murder.
yeah,
or-
I
and
don't think that'll
manslaughter.
stick.
Manslaughter.
I think
sure.
manslaughter may stick, but
Nothing else.
that's the most.
Well, the prosecution has to really tie it all up in closing arguments, but
Well, there is one piece of fairly compelling evidence that they got, though. When they had the doctor up on the stand, I think it was when they had the doctor, the forensic pathologist up on the stand.
today, you mean?
Yeah, and apparently, he was talking about Zimmerman. They showed some photographs of Zimmerman with his nose out of whack, and some dried blood down here. But then, and presumably that would have come from
Andrea, for item number
from Martin. Yeah, from Martin hitting him.
Was it that guy?
But
Item number 6.
there was no blood on Martin's hand.
Come from blood.
So, where is the evidence that he was under attack?
Yeah.
That Martin was
The thing
attacked?
is,
the complaint
the thing
filed
is
by
that
Glad
hasn't
the
been
complaint
discussed
filed
much is that
of
if you're assaulted first, you have every
Okay.
right to fight back.
Yeah.
So, and the assault doesn't have to be,
'Cause it does-
a punch in the nose or something like
doesn't-
that. It can be, just, or a threat. You can fight back if you
Which one was
receive
from the
a
guy?
So you could
That
argue that
the,
Trayvon felt
when we
threatened by
do,
this
I'll
following
do it
him
under
around.
comments for future agenda items.
That's
So
fine.
he had every right to defend himself.
If we're all still
Agreement
awake by
with
then?
that?
Yeah.
Okay, great.
Yeah, okay.
So in that case, wasn't the
I
aggressor.
said today when
And then you think he's 17 years old,
I'm good till about 9.
just as big as he was, and he had a gun. So why is he the victim here? I've really gotten caught. Melissa,
Oh.
massive hunger strike going on in the prison.
Oh, it's Fulton Bay, yeah.
Well, I mean, it's all over now. She said 30,000 inmates this morning refused breakfast.
Go. Ooh, look, I'm trying to.
And her client on death row. And she's going to go fighting
Michael Petrellis.
special
Stay away.
administrative member of a gang, and they're trying to keep him away.
Yes.
They're trying to separate all the
So
gang
like
members.
Scott said,
Kind of.
I was talking to Scott the other day, and Scott's like,
Yeah.
There was a big meeting yesterday with
Yeah.
physicians.
But you know
talking
the other guy who
parties
has
about
it?
their clients who are going to stop eating.
Look, I'm like,
She's out there, so we'll
Cotter's
just.
office.
Louise is out there?
Yeah, she's out there.
You get the audio back?
The last time I was here, he looked really
Okay, cool.
Other states
Okay.
have made it.
I'd like to call this meeting back to order. Oh, there's Louise. Madam Clerk, can you go to the next item on the agenda, please?
Item number 7, file number 13.
Five.
Where am I?
File number 13011, the second one from.
Yeah, item number 7, file 13030. I have it wrong. Okay.
No.
Okay, 130. Hold on. Okay, thank you.
I believe we're on item number 5.
Okay.
File number 13011.
Oh, 13011.
Yeah.
I'm sorry.
It's okay.
Filed by Paula Detech against the Arts Commission for allegedly not providing documents relating to Evelyn Russell, former Arts Commission Secretary. Thank you.
Okay, great. Let's, the matter of jurisdiction, I believe has been accepted by both parties. Yes, okay. So I would like to call for a motion to accept jurisdiction.
So move.
Can I get a second? Mr. Oak.
Second.
I'll get you some water. I would like to
Public
ask
comment.
this. Say it again?
Public comment.
Yeah. I'd like to see if there's any public comment on this issue of jurisdiction. If not, I can't see. If not, public comments closed. It seems that this motion is passed without objection. Great. Okay. So let's move on to the next item. Would like to talk about the substance of the complaint. I'd like to ask the complainant to come back up, and you have 5 minutes to make your case.
The history behind my wanting information on this former employee of the San Francisco Arts Commission, not that I even know who it was that in some very bizarre manner in 2005, I believe it was, I had to go through some hearing in some incident many years before at the street artist level. Lazar told me to call him when there was a quorum. And as I've already demonstrated to you, they never pick up the phone. DCA Kathy Barnes told me to follow up with an email every single time. Why is it that when I call Lazar's phone number 252-2583, some woman picks up the phone? Why is she saying bizarre things like, and I'm not even talking, Paula, why you're going to jail? All this kind of sordid nonsense that, I never even talked. I would just follow up with an email. That street artist meeting did take place, but I was arrested a week afterwards. It seems a little bizarre that Russell filed a complaint claiming that I was stalking her, with, of course, no evidence, without the knowledge of Lazar. I never got to the bottom of it because essentially there was no hearing. I spent 45 days in the San Francisco County Jail. Through Nick Gregoratos, the San Francisco Sheriff's Department, a letter came after the arrest and while in custody that the phones were rolling over. Okay, so 45 days in jail, and then I commuted from the East Coast for 2 years to make court dates. There was never a hearing. Neither Lazar nor Russell appeared in criminal court. So the case was dismissed. And when this happens, when you cannot meet your accuser face to face, you don't know who it is, and this, these allegations continue so many years later, it leaves a hole in your life. You'd just like some kind of closure or even recognition that it happened. And that's what I was trying to do by getting a few bits of paper that, that would just tell me that this woman existed and move on with your life. That's why I filed this information request, which, again, wasn't answered. Again, I filed it in the proper manner. I went through what I needed to go through in order to get the information. I did not get the information. There was not even an acknowledgement that I had even filed anything. And in the memorandum on this, there's some history behind it. Okay, I quoted the wrong section of the Sunshine Ordinance. I was asking for specific information on this employee, which of course I didn't get. And again, Paula Jensen tried to get it, and again, there was the usual resistance. We don't know her email. She has 20,000 different emails, and on and on and on. Eventually, Paula Jensen sent me 6 pages of the Pledge of Allegiance. That's what I got as information. She went out of her way and she mailed it to me. I was afraid to walk into the city attorney's office to pick it up. That's what I got. That does not fulfill this record request. Okay.
Thank you.
Thank you.
Are there any members of the public that want to offer any facts and evidence to Ms. Detesh's claim right now? If not, I'd like to, once you sit down, invite Mr. Lazar up to respond. And you too have 5 minutes, sir, again.
Thank you, members. Howard Lazar, Street Arts Program Director of the Arts Commission. We wrote to you on March 25th of this year, and in our letter to you, we mentioned that on January 16th, a similar complaint by Ms. Datish was heard by you, and about us allegedly not providing documents relating to Evelyn Russell. And at that hearing, there was a lack of a motion, and the task force found no violation. Now, during the hearing, the Art Commission provided ample evidence that it had been responsive to many similar requests made by Ms. Datish, and attached to this letter, we gave a sample of the correspondence, and we fulfilled our obligation to provide the information. Now, I will give you a chronology of our responses relevant to this particular request for information about Evelyn Russell. On August 1st, 2012, and on August 7th, 2012, personnel records of former Arts Commission Secretary Evelyn Russell were provided to Datish with the explanation that the documents were redacted as exempt from disclosure because of their containing personal information, the disclosure of which would constitute an unwarranted invasion of privacy. And I worked with the city attorney on all of those documents. I followed the city attorney's advice. On August 21st, 2012, we responded to Datish's immediate disclosure request, which was forwarded by Andrea Osbury to myself, who informed Datish that the request necessitated a large number of records that required time for search and review, and that a 10-day response would be applied. 10 days later, August 31st, 2012, a full response was given to each of Datish's August 21st requests. Number one, we responded to the reason, her request for the reason for hiring police to attend the Street Artists Committee meetings. Number two, the program director's report on enforcement for 2011 and 12, as well as the inspector's logbook entries recorded by myself, and monitoring notes submitted by members of the program's advisory committee, all of this explaining the program's monitoring system, which she was inquiring about. Number three, copies of the program director's timesheets from May 1st through August 30th, 2012. And number four, the date Evelyn Russell no longer worked for the Arts Commission, and the Commission's statement to Datish declining to disclose Evelyn Russell's records of health benefits and related payments due to confidentiality. On January 9th, 2013, there was a response to the email letter of January 8th, 2013 by Andrea Osbury to myself, asking if the Arts Commission further responded to a July 16, 2012 email to the Sunshine Task Force. I responded that I had already responded on August 1st, August 7th, and August 31st, 2012 to Datish's request for documents relating to Evelyn Russell, as I've already stated. Okay.
Thank you. Are there any members of the public that would like to support any additional facts or evidence for Mr. Lazar? If not, I'd like to open it up to the task force to ask any questions. Bless you. Ask any questions that they might have of either complainant or the respondent.
Questions?
Oh, Member Pilpel?
Thank you. Sorry, I think the cold's coming back. So first to Ms. Ditesh, I'm trying to find your original request, and I'm not finding that in the packet. Can you tell me what immediate disclosure request this was in reference to?
Yeah, I followed an email request, and then 10 days later was a follow-up form that you get from the clerk's office that was dated 17/13.
I think it was actually January 17th of 13. But where's the original email request?
Original email request.
That you made various references to? I didn't find that in the packet. while you're looking for that, to Mr. Lazar, the March 18th letter from the commission makes reference to attachments on the bottom of page 2 of that letter and references attachments on page 3, but I don't see those attachments in the packet. Can you tell me where those attachments are?
Well, I know we have attachments here as to inquiring about how to get a permit.
Can you speak into the mic?
I'm sorry. I see attached to this letter of the 25th, I don't know, I don't have the other one in front of me, but we included running responses to her emails to us on how to get a license.
Okay, I'm just not seeing that in the packet, so can you direct me to where I could find that?
Well, we attached it to our letter of March 25th to you.
I don't have a letter of March 25th, I have a letter of March 18th.
Really?
Can you tell me if there's... Does someone here
Oh,
have
here's
a
a
letter?
March 18th. I do see March 18th.
Great.
Right here.
Page 2 on the bottom, during this hearing, attached you'll find a sample from previous correspondence, and it's referenced again on page 3/SPR enclosure, and I'm looking for those enclosures or attachments.
And I got them right here, and they were part of the packet that was sent to you.
Great, except that I don't see them.
Yeah.
Can someone help me with that?
I'm willing to hand this over to you now if you want.
Okay, but I'm...
Yeah.
Hold on.
Andrea, can you look and see if we provided it for a packet? Thank you.
Yeah.
That was my only question
Yeah.
at this moment, and Ms. Datesh, if you can find your original request?
Again, last week, I went into the clerk's office, and they copied both files. It was not in the file. And I
Not
don't
in the
s-
file.
No, and I don't see it here.
Okay.
Ms. Datesh, I have a question for you. So your complainant is alleging violation of Section 67.15 of the ordinance, which has to do with public testimony.
I know, I got that wrong.
So this has nothing to do with what we're talking about? So your
It was a
complaint-
records request that I made.
Okay, so that's...
And it was specific to records requests.
Did you let the administrator know that this had nothing, this complaint that you have, Section 67.15, was wrong?
No, because when you go in the clerk's office, they just give you a form, and you're kind of left on your own. And this was the first complaint that I filed.
So
They
what
don't
is your
they don't
complaint,
overs-
though? So what
It's a-
section of the, where do you see the violation of the ordinance? Which section are we?
I asked for public records. I didn't get them.
Okay.
Was not done in a timely fashion. It was specific to an Evelyn Russell, a former employee, and over 10 days have passed without a response. I went in and did this, and then 2 weeks later contacted Paula Jessen, who went through the usual Lazar resistance. She mailed me 6 pages of the Pledge of Allegiance on her own.
Member Nee?
Yes, thank you. Ms. Datesh, what was the date of that you made the request? I understand it was an immediate disclosure request, correct?
Yes.
What was the date that request was made?
It was sent by way of an email. It wasn't in the packet. There was very little on this case there. There was a memorandum.
Right. Well, in order to establish that there was, in fact, lack of timely response, we would need to know the date of the request. That's the first question I have.
August 1st, 2012.
That was okay, but that was I think that was in a case already, that already came before us, case number 12032. Isn't that correct?
At that case, the Arts Commission claimed to have sent me documentation, which I said I did not receive because they sent it to a bogus email, and it was included in the file. You could see the email that they sent it to. There was a mistake in my name. It's PDATESH@AOL, and they mistook the letter.
Okay,
They
it
sent it to the wrong
says
address.
that on March 18, 2013, you sent them a notice that 10 days had passed since you filed two
Right.
sunshine requests for information. That would indicate that you had made the request on or about March 8th, 2013. Was that the date of your latter information request?
Yes.
Okay, now, we've heard testimony and seen testimony, printed testimony, that you sent this by an email to Rebecca Krell. Is that correct?
No, I sent it to Howard Lazar, the custodian of records, and with the title "Immediate Disclosure
Okay,
Request."
we don't. I don't see that request. I don't see the copy of that request.
It wasn't in the file. I copied it last week. I went in and they copied everything they had. This is what I had. This
Did
is
you
what they gave me.
send a copy of that email to our administrator for inclusion in this packet?
10 days after the immediate disclosure email, I walked in and filed this. This was the first sunshine request I made.
Have you sent, for inclusion in the packet that we're looking at today, a copy of the email you sent to Mr. Lazar?
At the time I did. I don't know why it wasn't in the packet. It wasn't in the file either.
Okay.
Do you have a copy of that?
No.
Okay,
I might have
that's
it
a
on my
problem.
computer.
Okay. Let me ask you one or two other questions. You were provided with some information following the request you made of on August 1st, is that correct?
Not through the normal chain of command.
Well, but
yes.
you did get information. Is there any information, is the request that you made on or about March 8th, was that for information that you had not already received?
I had never received any information. I had never asked for it before. I was asking for all documents relating to Evelyn Russell, former employee of the San Francisco Arts Commission.
And that's, but isn't that what you asked for on August 1st as well?
Of what year?
2012.
Yes.
So you did ask for that on August 1st, 2012.
Yes.
And the matter came before the task force as case number 12032, and the task force failed to find, the task force was not convinced that there was violation here.
Actually, what happened was there was a lot of documentation in the file, but I had not received it because it went to a wrong email address. That's what happened that day.
But you since did receive it.
I got nothing. Nothing at all. Yeah, I agree. It's confusing. Very.
Well, the timelining on this is Byzantine, to say the least.
Well,
Member Pilpel?
Let me try again. Maybe I can find something here. On page 170 of our packet, the memo from Deputy City Attorney Threet suggests that the complaint was filed on January 17th. That checks out with the complaint form that's several pages later, dated, timestamp January 17th, which makes reference to a prior request. And on page 3 of that memo says attached to this letter referring to the March 18th letter from the Arts Commission were multiple emails between the parties, et cetera, et cetera. So perhaps to Mr. Threet, since you authored this memo, did you actually see and review those referenced emails from August 1st, August 7th, August 21st of 2012?
You'll have to ask the question again, Member Pilpel.
Sorry. You make reference on page 3 of your memo to multiple emails being attached to this letter, those emails dated August 1st, August 7th, and August 21st, 2012. Do you recall actually seeing and reviewing the content of those emails?
Yes.
You don't happen to have them with you?
Nope.
Okay. And Ms. Osbury, you don't happen to have those with us? Have you had a chance to take a look at the complaint file?
Yes, are those attachments or an actual email?
I can't, it suggests that they were attached to the letter, and somehow they got to DCA 3, but don't appear to be in the packet right now. Do you happen to have the complaint file, and can you take a look and see if they're there?
Through the chair to Member Pepel, typically when there are when I receive documentation, it comes as PDFs from an email from the administrator, and typically if there's a letter from the respondent, that is one of the attachments, and then any documents that are alleged to have been responses to the complainant are typically in another PDF attachment to the email from the administrator. So typically they come in multiple attachments to me in an email.
That's fine.
I'm just giving you information.
No, that's cool. That's helpful. I'm just trying to figure out if they are in the room somewhere that we might refer to or not. And it seems to me like there either was. Sorry? Oh, Mr. Lazar has them? Okay. Well, maybe we need to take a quick look and see what there is there.
I don't have them.
Okay. Well.
And these were the emails from between Mr. Tuck?
Okay. So it appears that there was some email exchange in August of 2012 that was probably dealt with by the task force in January in complaint 12032.
So what
I'm trying to figure out is, was there an email subsequent to that that asked the same or similar or different information that triggered this complaint, or is this really the same sum and substance as the complaint that was heard by the task force in January, in which case perhaps we just reached the same conclusion and we're just spinning our wheels?
Well, he's quoted additional information. He's added more to it than these Evelyn Russell records. So this was a different complaint.
No, I don't. Mr. Lazar, can you come up and respond, please? I don't think that's what he's saying.
I didn't add anything. I'm just going by what's here.
What's in the
what we
packet.
sent you, and I didn't add anything.
For the previous case, correct?
Yes, I know that's yes, because we were describing the previous case, which was a dismissal.
Exactly.
Right.
Okay.
Yes.
Thank you.
I guess my follow-up then is to Ms. Datesh. How is this, and maybe Member Nee already asked this, and I'm repeating myself, how is this different from 12032 and the request that you made in 2012 relative to Ms. Russell? What is different here?
It's a separate request asking for additional information. It's not in the file. It's not available here. It's only in Lazar's hands. I didn't get it.
Well, if you didn't file it with the task force, then I don't think we can hear it.
I did file it with the task force.
Well, could you help us find it?
If you don't have the document.
I'm sorry. I was in the clerk's office last week. Ms. Osbury left the files at the front desk. I asked them to copy everything. I came back an hour later, and that's what I received. There was nothing in it. What I have on that file is before you. It's not even in the public information thing. I have not gotten any information.
But what did you provide us to begin with? Did you provide
your
us
initial request?
Your initial request?
That's the question.
What we're looking for.
And you have to have a copy of it. If otherwise, you have that. That's your initial request?
Yes.
What's the date of the letter?
March 19th, 2013.
Yes, we have that in our packet. That's on page 188. But the original request should predate January 17th of 2013 when you filed the complaint, to which you were referring to a past request.
It wasn't in the office in the file. It's not here. I could not copy it.
Did you file that with us as part of your complaint?
I did.
Okay.
But if you don't have any, if you don't have the documentation in even your personal records for us to even look at this case.
There's a reasonable degree of expectation that when someone is walking into a clerk's office to copy a file, the majority of it isn't missing. I didn't realize that I needed to keep separate files. I was requesting information. This information, or the information that he has, should have been included in the file.
It is in the file.
Well, it's not here. I didn't get it. It wasn't in the file when they copied it last week.
Member Nee?
Madam Chair, colleagues, I think what might be appropriate at this time would be to continue this matter till next month, to give both sides the opportunity to provide all of the information that they can relative to this case. Some of it may have been provided and gone missing somewhere, and I'm not casting aspersions here on our administrator. That is certainly not intended, but obviously there is a lot of information relative to this case that we simply do not have, and without it we cannot make any kind of a sensible judgment here.
I agree. Member Oka?
Since it's obvious that none of us has what we need to proceed with this, I will move to continue this to the next meeting.
Second.
It's been moved and seconded to continue this for the next meeting.
So
I'd like to open up now.
So I'm with that, but I want to be clear on what we're looking for, that it's the attachments to the March 18th letter, however they get to the file, Mr. Lazar, Ms. Detesh, Mr. Threet, Ms. Osbury, somehow that needs to get in the file and be before us. And
the initial request from Ms. Detesh.
The initial request from Ms. Detesh, whether it was...
I have it on my computer.
That's what I was asking.
So if you can provide a copy to us, that would be fantastic.
Provide it to the administrator as soon as possible, and then for the next month's meeting, we will have all the documentation so that we don't get here and think that that is the complete file.
And if we can be real clear as to whether the underlying request was August 1st or some other date, that would be good to know. And if it's the August 1st, then we've presumably got that somewhere. And if it's some other date, we'd like to see that initial request and whatever response, so we can follow the timeline here.
It needs to be.
It
needs to have been. It needs to have been a different date. Otherwise, we've already seen this case. If it's the August 1st one and ruled on it. So we are assuming that it's a different case. Otherwise, if it's all the same information, we've already ruled on this. So we need to see what is the different information that you requested and filed, and also, in your mind, know that it's not 67.15, so
yeah,
it's
that was the
something
first
else.
one I filed.
Mm-hmm.
Okay, so can you tell the respondent that any information or documentation to include it in the file so I can finally get it?
Yes, Mr. Lazar, if you could provide that information to our administrator, who will make sure it's
Okay,
disseminated.
I want to clarify. I have provided everything we have, including the reasons.
Okay.
And I do have a request for you. Whatever she sends to you on this new round, I would like a copy of.
Absolutely.
Thank you.
Thank you. You can speak in the mic, because I can't hear you.
Simple English, does that mean that he's going to put the information in the clerk's office?
Yes, in simple
Thank you,
English, that means it will be in the clerk's office, and she will disseminate it to both parties that are involved in the case, meaning you and Mr. Lazar. I'd like to open up to public comment. If there's any public comment on this particular matter.
Peter Warfield again. I'm not a party to this case, but there is on your page P180 a letter from apparently Mr. Howard Lazar to the complainant, and it says, "Dear Ms. Detesh, we have learned from the city attorney's office that you have asked for the following records," and then it quotes, and perhaps she can confirm, it quotes what presumably she has asked for, quote, "all records concerning Evelyn Russell, a former Secretary of the San Francisco Arts Commission, period. I am interested in internal emails between Howard Lazar and P.J. Johnson, former president, concerning, and so on and so forth. So it looks as though there's a full, it looks as though there's the information that you might be seeking in the letter from Mr. Lazar to her, quoting apparently, again, I'm not sure of the accuracy, that might be something discussed or asked, but it looks as though there's a specific and exact quote of what was requested here in this letter dated August the 1st, and it's being sent at 10:05 a.m.
And our belief, just to clarify, is that that is the previous case that we have already ruled on from file number 12. What is it? The previous one? 120. What is it? 12032? Yeah, from that previous one.
Okay.
So that's the information from that. So that's why we're requesting the new. Where is the new information for us to move forward on the new one?
Thank you.
You're welcome. Is there any more public comment on this? If not, I'd like, Madam Clerk, can you take a roll call vote on the issue of continuing item number 13011 till next month's meeting by getting the additional initial request from Mr. Tesh, as well as any other information if Mr. Lazar has anything different.
Okay. Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Pilpel?
Aye.
Pilpel, aye. Member Sims?
Aye.
Sims, aye. Member David?
Aye.
David, aye. Member Highland? Highland, aye. Member Oka?
Aye.
Aye. Member Fisher?
Aye.
Fisher, aye. And Chair Grant?
Aye.
You have 9 ayes.
Great. So this will be continued to the next. And you guys understand what we're requesting of you. Great. Thank you. Thank you for being here tonight, both of you. Madam Clerk, can you go to the next item, please?
Yeah, sorry. File number 13013, complaint filed by Ray Hartz against Louis Herrera, City Librarian for allegedly abridging public comment by allowing selective accessibility of library audio-visual equipment.
Okay. Has jurisdiction been accepted by both parties? Mr. Hartz and, okay, you accept, okay, great. So it's accepted by both parties in interest. Can I get a motion to accept jurisdiction?
So move.
Can I get
Second.
Okay, it's moved and seconded to accept jurisdiction. Is there any public comment on this issue? If not, I believe everyone in the task force is in agreement. I'd like to declare the motion passed without objection. And I would like to now move to giving the opportunity to Mr. Hartz.
Was there any public comment? No?
No one had public comment. On the hearing of the, oh, there you are. You have 5 minutes to present your case to us.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. This is a pretty clear case. We live in a day and an age where everybody uses audiovisual equipment of some sort. And every city body and commission and board that I attend, if there is audiovisual equipment, it is open to all members, including the public. The library has a system in Corette Auditorium and basically denies access to members of the public to use the audiovisual equipment. The problem is that it is discriminatory treatment. This is a document that they used on the audiovisual provided by the Friends of the San Francisco Public Library. I think if you look at it, you will see it is in a PowerPoint format, and they simply submit it to the library, and they put it into the audiovisual equipment and show it on the screen. Now, I asked Ms. Blackman just this very morning, I said, how do the Friends and other groups that are invited to participate do that? Do they submit a PowerPoint presentation? And she refused to answer. She said, oh, that has nothing to do with it. And I submitted very much does. They go through this argument saying, well, you're not invited. Well, that is viewpoint discrimination. Obviously, if a board or commission is allowed to simply decide who can use their equipment based on who they want to invite, they're going to invite, and they have in the past invited people they agree with, like the Friends. And the Friends are allowed to use the equipment, present their things, they get unlimited time. Now, the members of the public they're limited in time, they have 3 minutes, and they're denied access to this equipment. Mr. Herrera put in another argument saying, oh, well, we've looked into this and we would have to spend $41,000 to make, put in special projectors and all this other garbage, which is one of those straw men. Bottom line is, I have offered on 3 separate occasions to say, I will do exactly what the Friends do. I will send you an email with the PowerPoint slides attached, and you can simply put them in. They have refused to answer that at all because, bottom line, they have established a pattern of behavior. This is the same group who's denied access to the 150-word summaries in the minutes for 2 years. This is the same group that has denied access to public records and has been referred.
Sorry, what's that noise? Okay. I didn't know it was disturbing you either, so. Do you hear it?
I heard sort of a...
Okay, go on, I'll give you your time.
Okay. So basically, we're not asking for special treatment, we're asking for equal treatment. If you can take slides from the groups you like and put them into your presentation and make it accessible to them, there is no reason why you can't do the same for members of the public. And basically what this really comes down to is viewpoint discrimination, which is specifically prohibited by law at local and state level. And it is abridgment of public comment. People cannot be as effective as they can be if they're denied the use of audio-visual equipment when the people on the other side of that...
Somebody's got a device that's too close to a mic somehow.
It's not ringing.
Okay, sorry.
Okay.
We'll give it back to you. Sorry, yeah.
Yes.
It is not reasonable to say if I have one opinion about something that this group, the Friends, has been allowed to have unlimited time and access to the audiovisual equipment, and yet I've denied the access to the audiovisual equipment even with my limited time and allowed to make a fair point. Now, their arguments are specious. They do not like what we have to say. This is a matter of public record. They have on Library Commission meetings said repeatedly, we don't like what they say. They're always negative. They talk too long. They talk on every item. It's a matter of public record that they don't like what we say. And they have made every effort to keep what we have to say out of the official record. They finally, in January, agreed to follow the Ethics Commission and put the 150-word summaries. We still have a 2-year complaint for requesting public records that they've denied. That's been referred to the Board of Supervisors. Bottom line is they don't like the fact that we challenge what the Friends do, and they do not want us to be effective in what we do. Okay. So basically, if I were, they raise these straw men, say, oh, you want us to put in $40,000 worth of equipment. Nobody ever asked for that. I made it very clear, and you can see it in the emails. I said, Mr. Herrera, I will submit to you a document in PowerPoint format, and you can simply do what you do with all these other documents and put it in. And their response is, well, you aren't invited. And again, that allows viewpoint discrimination. It basically says, we'll just invite the people who agree with us, who want to praise us, who want to say things are all wonderful, and anybody who has a different viewpoint, we're going to limit what they can do. Very honestly, the Library Commission and the city librarian look at me and certain other members of the public as people who have very effectively challenged the tens of millions of dollars the Friends have raised, and raised the issue that the Library Commission and the city librarian have absolutely no records to support where that money went. They come before the public and simply say, this is a wonderful group, everything's wonderful. And today I had a conversation with the chief financial officer, and I asked her, I said, what does the city library have to show what the $50 to $60 million they've expended in the last 10 years, where it actually went? Her answer, nothing.
Thank you. Are there any members of the public to offer any evidence or facts in support of Mr. Hertz? If not, I'd like to invite the respondent up. And you have 5 minutes to kind of give us the...
Thank you.
You have the case.
Good evening, members of the task force. I'm Sue Blackman, Library Commission Secretary, and with me tonight is Roberto Lombardi, the library's Facilities Director. He will go over the technical aspects of our response. I want to make sure that you have the letter of March 5th that was in your packet. I have extra copies if you need them.
It's packet page 231.
City Librarian Luis Herrera wrote to Ray Hartz on... I think it's a little better than the one that was in the packet.
Here, if you need it. No, if you want a hard copy, too.
Mr. Herrera explains...
Thank you.
Okay.
Would you like a PowerPoint?
Mr. Herrera explains the reasons the library is not able to allow members of the public to use audiovisual aids to support public comment. Currently, the Library Commission allows only staff and individuals or organizations invited to make presentations for items that the Commission has placed on the agenda, to use the library's computers to connect to its audiovisual equipment. For example, the architects, as part of the bond manager's report, other city departments, or the Friends of the Library have on occasion connected their laptops or preloaded materials to library audiovisual equipment for presentations that the Commission has invited them to make. Otherwise, the library uniformly declines to allow members of the public, without regard to their viewpoint, to connect their laptops or external devices to the department's audiovisual equipment because of the additional expense. And Roberto Lombardi will now explain what would be involved in order to accommodate Mr. Hart's request.
Hi, good evening, members of the task force. Thanks for having us here to explain our perspective on this. I did want to mention, I'm mainly going to speak about the technical aspects of this as the facilities director and the buildings person, but my understanding of our procedure too is that I just wanted to add on, Sue, that the Library Commission actually invites people to give reports on topics of interest to them, things that they may have to vote on, make a recommendation on. The Friends of the Library nor anybody else they need to be invited. So if a member of the Friends of the Library is in a commission meeting, they also, our rules for public comment apply to everybody. There isn't any special favoritism. So the issue here is really perhaps the Library Commission is inviting people to do a presentation and is using the AV materials to enhance the information that they will get to make decisions, et cetera. And I do understand and I respect that there are other opinions on that, and I just wanted to add that. But I'll speak mainly to the facilities end. I know that I've worked for the city for a long time, and background-wise, I was a general contractor for years, worked for big commercial contractors, did a lot of work at SFO, and have worked on this building and Moscone West, so I feel I'm pretty qualified to talk about construction matters. Unfortunately, when you start talking about doing construction projects in the city and the civic building, the costs actually do often rise to a level that's hard to believe. I know that there was a lot of controversy when the Board of Supervisors chamber here was, there were some ADA issues in terms of making accommodation there, and the prices of that work shock people. It's a similar thing at the library. The reason that this cost is very, very high to make accommodations is if we do, we'll have ADA issues to contend with. We have to be very, very careful about those. We'd work with the Mayor's Office of Disability, and in our experience, there are often a lot of unforeseens that come up with that work. Coring at the library, we can't simply run cords across the floor from the podium. We would probably have a new podium similar to what was put in our Bayview Library, which is an ADA podium that rises and lowers to accommodate people's needs. We'd have to core through the floor. We would have to do the job properly, essentially. And for instance, when you core at the library, you have to x-ray the floor first, because unfortunately when the building was built, all the wires were installed in what's called spaghetti tube, which basically means they're willy-nilly all over the floor, and we've had very negative experience with coring into a power line with unfortunate effect. So it's a large expense, and we have a lot of other competing priorities. I did get an estimate, put together an estimate. It included a $30,000 cost from DPW for the electrical work, the coring, the conduit, et cetera, to do this job properly. And what I would say is this, is that certainly these kinds of things are physically possible, but I would not be able to make that kind of expenditure. I wouldn't comfortably make that without going back to the Library Commission. I think it's a large enough expenditure that we would want it to be part of the budget process and perhaps part of a larger conversation with the Commission in that case. I hope that's helpful. I'd be happy to answer any other questions.
Great, thank you so much. Is there anyone in the audience that wants to offer any facts or evidence in support of the respondent? Oh, sorry, and the respondent. If not, no. I'd like to open it up to, and I have the first question, if that's okay. I have a question too. Ma'am, can you come up? I'm sorry. Or both, yeah. So my question is just, it's kind of common sense. So if you already have the equipment so that the people that are invited can come and present if they're invited, why is it so difficult to meet Mr. Hart's request? I know that you have something that says you don't allow the public, but then that does kind of concern me because you aren't being able, if they want to be heard in a certain way, and he offered, I was looking at his letters, he offered to present certain things, and if he was to do it in the time limit, for public comment and things like that, I just want to kind of understand why that would be an issue, because it seems like you already have the equipment. If he was just able to do a PowerPoint or just a simple slide thing like we do for our meeting when someone requests that. We try to have, we don't have one today because it wasn't requested, but
I think Roberto might want to respond to that.
Either one of you, yeah. Mm-hmm.
Thank you. It's not directly facilities related, but I think part of the issue is that with our IT staffing, that there is some concern about, for instance, we don't really want to have people bring a jump drive, that kind of thing, to go onto our computer system. I mean, that's my understanding of our IT division's concerns. Part of it is staffing wise. We already are kind of stretched with all the public programming we do everywhere to have AV staff. It's the same AV staff that does all the programs and all the branches in the main that also staffs the Correct commission meetings. Mm-hmm. And so, we just have some questions too about what the staffing capacity would be there, and we're just always trying to weigh. I respect that members of the public think this is an important priority, and I understand that. But we're trying to weigh also our resources in terms of technical support. There are a lot of constituents for the library who would, have other ideas about where we would best put that support in terms of staffing, not only the technological cost. So as I mentioned, the kind of cost that we're looking at for the equipment, if we did this properly with the proper ADA podium, et cetera, I can paint the interiors of 3 or 4 branch libraries for that kind of money, and there'd be a lot of people who would...
So when the friends of the library are invited, they have this, it's the same...
What typically happens is usually in terms of making it an efficient process,
yes.
And sometimes I do this myself if I have to do a report on, say, the condition of our facilities or security, incident reports, that kind of thing. Usually we internally will assemble a PowerPoint so that it goes smoothly. So what happens is essentially you get a PowerPoint assembled, and if somebody's invited, an outside consultant or another agency, DPW, et cetera, they will get the file over some way, and then the IT and AV divisions basically look at the file and they assemble it ahead of time for the meeting. That's the typical process.
So to Mr. Hart's issue that if he were to do the same thing in advance, is it because you're saying you don't have your team does not have the time to meet those kinds of requests because it would just start to, you feel that would become too much? Or?
Well, I can address that as well as I can as the facilities person, but
exactly.
I think that's part of the issue is just resources, basically.
Okay.
Yeah.
Okay.
And I do, so it's a little different from, I know the way the Board of Supervisors chamber is normally there's some equipment there, so you can actually show up, you can just take out a piece of paper and start writing.
Exactly.
And that's where we especially
put the piece of paper down so we can see it and look at it on the screen. You don't have that
No, we do
available
not right now. In fact, unfortunately, when the Correct was built, my understanding, I wasn't there in '96 when it opened, but that apparently at the last minute, the designers realized that they hadn't provided a podium for any public comment, and so that was done in kind of a hasty manner as the building opened. And that's part of the reason why, plus codes changed, that we have kind of a podium situation there that's not what you would see if it were built today.
Okay.
Safe to
Got
say.
it. Okay, thank you.
Actually, I have a question for both of you, I think. So, Mr. Roberto, I only got your first name.
Lombardi.
Lombardi, I appreciate everything you're saying. I've built data centers, hundreds of data centers all over the world. I've core board, I've gone under floors, I've gone over ceilings. I get that, I know that. I don't think that's what Mr. Hartz is really asking for. So I think I'm going to ask Ms. Blackman, was it? And your position with the library
I'm the
is?
Library Commission Secretary.
So, I think what I'm getting at is, I get it. I kind of think you're sort of out of this. We understand we're not asking you to move God, mother, and country and change everything around. But what I'm getting at here is, I think all Mr. Hartz is asking for is a simple, hey, I know, you know, every month there's a commission meeting. You probably have it on your calendar. And if maybe we could compromise and say, hey, you get us that PowerPoint within 2 weeks. I agree. I'm very fearful of, viruses. I work for a major company. We've got over 500 million subscribers. We take that very seriously. But I know that our internal processes here within the city have virus software. So maybe if Mr. Hartz would email this PowerPoint presentation, it comes through IT. I mean, it's very simple. It checks whatever virus software we have, checks for, for any kind of virus, and then boom. And I'm not just saying you open up to Mr. Hartz, but would it be that much of a burden if, we're all about openness here. We're all about openness here. I mean, would it be that much of a burden if people were, and I'm not saying that, you have to do it immediately when people show up. I mean, give people a reasonable amount of time. You got to get to us within 7 days. I mean, is that something you'd consider? Am I making any sense?
Yeah, no, you are. I think the issue is the time constraint. It would take someone time to load it and check it and make sure that it's not, has a virus or whatever. We have several speakers who speak on several items, and if we open up to one, we must open it up to everyone who wants to do that.
Can't you limit it to 3 minutes, though?
No, it's limited to 3 minutes.
Yeah,
I'm
so
just saying, if several people came in and wanted to do PowerPoints on each item, it would take a lot of staff time to do that. And the other thing is, we don't have staff down below. The media IT people are up in the booth. So if, there's a glitch, there's a problem, they're going to have to come down. We just don't have the staff to do that.
So you don't have a process in place for the public to say, just like Louise was just saying, that if you had a process in place that the public wanted to do public comment and they let you know in advance that this is what they want to do, and everyone's not going to have a PowerPoint presentation. They're just going to have probably just some slide or something that they want to present. It just feels like they're not being given the opportunity. Member David.
Yeah, so a couple of comments. First of all, I love our library system. I think it's amazing. My children use it all the time. So I'm a huge fan of the San Francisco Public Library. I'm concerned, deeply concerned, about the seemingly unequal treatment of a group like Friends of the Public Library, which is a private organization that is getting a clearly preferential treatment over a member of the public. And that just, that in and on its face concerns me.
It's only preferential because the commission has asked for that report, and it is an agenda item on the commission agenda.
Yeah, fair enough, but fair enough, but at the same time, I mean, there is this very close multi-million-dollar relationship between the Friends of the Public Library and the library. I mean, it's a little bit closer of a relationship than just, they have some information and we're asking for that information. And so, it seems to me that what Member Fisher was recommending and what I've heard other kind of people recommend is that it seems reasonable that if you were to provide a guideline for providing public comment, and that if people want to do a PowerPoint presentation and said you need to have, dates, and you need to have, and give timelines, and hey, by the way, we know there's technical glitches that can happen. We can't guarantee that, that seems like a reasonable thing for San Francisco Public Libraries to at least give the appearance of interest in equal treatment of public comment. I mean, as it is right now, as someone who is a huge fan of the library system, I have to tell you, this seems on its face really, really odd, the way that it is now.
Yeah. Member Nee?
Oh, I'm sorry.
I'm sorry, do you want to respond to that?
If it's okay, I have to agree that I can understand why it would look that way, but I do want to point out that the Friends of the Library reports, they keep on being cited, the Friends of the Library. They're a very small percentage of the actual reports we get. We have other, there are other reports that come in too. For instance, Public Works will be invited to come and report on the progress of the BLIP program. And there are a lot of internal reports that specifically the commission asks for. They want to know what's going on with teen programs, and so this thing is put together. So the intent really of inviting people to do a presentation is to provide all this information. And I do think there's a little concern. It's hard to really argue against if one person comes and does a PowerPoint, how big of an impact is that going to have? But we do have very, very interested members of the public who do come frequently to our meetings and do make a lot of comments. I mean, that's very active. And the fact of the matter is, if we have 6 agenda items, that's 18 public comments, that's 18 presentations, potentially. I understand that we might reasonably think, well, we're probably not going to get 18 of them. But the potential is there to have 18 of them, and we do have I just want you to know that our concern about staffing is not frivolous, because we don't have big staffing for these things. And
I still think it comes down to a matter of process, though, because it is 2 separate issues. When people are giving presentations because they've been invited, that's a completely different thing. It goes back to the public right now. I think that's what we're talking about, public comment and having the opportunity. It's about getting, I guess, a little bit, you're used to people just talking, but there's other ways that people communicate, and people can communicate via, audiovisual equipment in this day and age, or internet or whatever. Right. It just seems that you have these presentations, and then the public is not being given the opportunity. Maybe if they, express themselves better with some kind of audiovisual, and they have the 3 minutes, you could develop a process that you can't do an audiovisual for every single item, that there's one. I mean, this needs to be worked out, but it just seems like you need to kind of try to figure this out or talk it out, because this is going to come up more and more in this age of internet and audiovisual and things like that, and you're limiting the public. I mean, that's how it appears.
The complaint is that we are abridging public comment, which we absolutely are not abridging public comment. There's nothing in the Sunshine Ordinance that addresses audiovisual equipment or whatever. Believe me, if we could do it, we would do it. If we had our meetings at City Hall where it's all set up to go and do it, we would do that. But we're not set up that way, and it is going to incur an extra cost to do what he wants us to do, to have it fair to handicapped people or whoever comes in and wants to make a presentation. So somebody comes in a day late, they don't get it in, it's going to open up a problem.
Member Sims?
I mean, I do understand what all the members have said and what you just said, but I think I want to just touch on something that we really haven't touched on really quickly. Is you have framed the argument into the public comment section, and that we're not abridging either public comment or we're not abridging public criticism. But have you ever asked Mr. Hartz to speak as an agenda item?
No.
Have you ever asked Mr. Warfield to speak as an agenda item?
No, the commission would have to do that.
Okay, so have you ever asked that you are aware of any person who is negative or dissenting in any way of the public library in San Francisco as an agenda item?
I can't answer that question.
As your memory would...
Mr. Sims, no answer to that question, though, but the purpose of the presentations, that's what the public comment is, to get the other point of view, which we get plenty of. The purpose of the presentations is to further the business of the Library Commission. They request these presentations.
And do they ever request the present? And this is from just your memory. Have they ever requested presentations from a dissenting party?
Not to my memory.
So what you were saying is that the invited are the people we agree with or want information from that may be positive, and the uninvited are either the public we agree with or the public we disagree with. And that, I think, is the heart of this problem, where you're not providing access and you're abridging those that have negative or criticism of the public. And I think that's what it comes down to. If you came up here and you said, oh, we have Mr. Warfield here, or when we have the Friends of the Libraries Users Association here, we also have an agenda item with the other individuals who are negative or anti or in some way not friendly to the library. So I think when it comes to that, under those circumstances, when we're asking for a small accommodation that can be done, I think that the section that's been quoted is applicable here of the Sunshine Ordinance Task Force. And I think that under those circumstances, to be fair and to not abridge the public criticism that may come, that you just need to formulate some procedures, and they don't have to be, overwhelmingly accommodating, but they have to give the public the opportunity if they want to go that extra step.
Do you guys have any response? If not, Member Oka?
Yes, Mr. Lombardi, I also have a problem with this whole concept that I'm hearing, because I've been on multiple commissions where we've spent hours and hours hearing public give presentations, whether we agree with it or not. And how many meetings of over 6 hours have you experienced where that is going to happen? Believe me, the Taxi Commission had many, many meetings over 6 hours. And we started at 6:30 in the evening, okay? So I think when it comes to public participation in your process, whatever it takes to make that happen, you must, and I repeat, must make that effort. And the other thing is, it doesn't take long to check for viruses. I could do it. I can do it within 3 or 4 minutes or less to see if anything malicious is within anything that Mr. Hart or anybody sends to me. So I don't buy it. I just don't buy it.
Madam
Thank
Chair.
you. Oh, Member Nee?
Yes, Ms. Blackman or Mr. Lombardi, what is the library's annual budget?
Well, to the best of my knowledge, it's hovering right in the range of $100 million right now.
$100 million. Okay. In his March 5th letter to Mr. Hart, Mr. Herrera says preliminary cost estimates from our facilities department, working with the Department of Public Works, places that cost to really do a proper AV system at a minimum of $40,000. Out of $100 million, that doesn't really sound like a lot. Have you or anybody else ever put in a request to the city to have that amount budgeted?
We have not, and I agree that that seems like quite an odd proportion. You do have to remember, of course, like the city budget, you take employee salaries right off the top, and you're talking about probably 3/4 or more of our budget. So, but I think you make a good point in that it is a matter that to do work of this kind, I would want the Library Commission certainly to be involved in that, both because it's a large expenditure, but also because it is a major modification to the Correct Auditorium. And it would be a process, because we would want to do this very, very carefully with MOD, because we'd want to make sure that it is done correctly the first time it were done, if that were to happen. In other words, I'm trying to explain that it's not, if we were to do the process, we need to accommodate everybody if we're going to do something. And I think that that could involve a lot of technical work in terms of the podium, et cetera. And such a project, I would think, would be something that the Library Commission would be wanting to review. I wouldn't be able to just make an expenditure like that without some kind of oversight and review.
Well, granted, but, in the interests of democratizing, if you will, public participation in Library Commission meetings and other functions that go on in Correct Auditorium, I would think this would be really a top priority.
Have you had many other requests? Do you get a lot of requests for audiovisual from the public?
We do not get a lot. We have had others.
Okay. Member Pilpel.
Thank you. First to Mr. Hartz. Other than Section 67.15, which you cite relative to viewpoint discrimination, I think we get that concern. Is there anything else that you find in the Sunshine Ordinance or the Brown Act that, in your opinion, requires the city or the Library Commission to provide access to their AV equipment for PowerPoint presentations or other sorts of things like this?
I think equal treatment under the law.
No, I'm asking if you find anything specific about access to audio-video equipment or computer equipment.
I'm going to decline to answer Mr. Pilpel's question because I do not respect his questions and motives.
Great, thanks.
Thank you.
So to Ms. Blackman, I think we understand the technical issues well enough. I think there's a policy issue that underlies the discussion here. I've certainly been to many, I wouldn't say many, to a number of Library Commission meetings. I would say that there is robust public comment on most every item, albeit from a small number of regular commenters and a large number of irregular, or another small number of irregular commenters. So, it's my general view that there is no shortage of public comment and public participation. However, this question of access to equipment to present in a different manner isn't currently available at Library Commission meetings, is available at City Hall and at some other types of meetings, but is not uniformly available at all meetings in the city.
Correct.
I guess I'm struggling with both whether it's required, and I'm leaning to no, it's not required, whether it's a policy call for the commission, and I'm leaning to yes, it's a policy call for them, and maybe something that should be presented and discussed so that this, some version of this discussion can be had with the commission and not just amongst us and maybe the city librarian, but that the commissioners should wrestle with this a little bit. And maybe, that could be either presented by staff or presented by members of the public. Either way, that discussion should occur. But I'm also thinking that just as access to AV equipment has changed And for that matter, televising meetings has changed the nature of meetings at City Hall, and the Board of Supervisors, for that matter, so too would access to AV equipment for these kinds of presentations inevitably change the tenor of Library Commission meetings. Some would say for the better, others would say for the worse. I don't know, but certainly different. And I can certainly see that for the average of 5 to 8, maybe 6 or 7 agenda items at every meeting, that there would likely be at least one individual, maybe 2 or 3, who would make presentations, and that would change the way the commission operates. Can you comment on how that has a broader implication either for members of the public or for the commission and its ability to get its business done?
I believe that it would, and I also agree that this could be something on the agenda for the Library Commission. I mean, we'd have to talk to the president of the commission and put it on the agenda for them to discuss, because in any case, they would have to approve a budget to do this. At this point, because the Sunshine Ordinance does not require there's nothing in the Sunshine Ordinance that requires that we provide audiovisual equipment, we are comfortable that we're providing public comment to everyone. And, we've made efforts. Mr. Hart's referred to the minutes. We have now put the 150-word statements in the minutes. We've made every effort. So at this point, without going through the steps of doing this permanently, all I can say is I could ask the commission to put it on their agenda and discuss it.
Well, so then, if I can just close, it seems to me like I'm not convinced that there's a violation of the ordinance, but I am somewhat persuaded that a letter from the task force to the Library Commission encouraging them to put this on their agenda for discussion would help advance the cause, or to those who support it, and that ultimately it is their call as to the budget and the facility modifications. No one's going to go in there and start carving up the auditorium without the approval of the commission and the city librarian. So that's not going to happen without the commission's consent. So I would be supportive of a letter from the task force when we get there.
I think that my concern still goes back to the idea. I would have no issues if that there weren't other audiovisual presentations that have been done for certain specific groups. So it lets you know that the equipment is there, and I understand it's problematic and all that, but it just really does feel as if some people are being left out, and certain. And I understand their public comment and all that, but if you have the equipment, it just feels like you're not attempting to maybe help out the few people that are requesting audiovisual. And I bet as we go through the years and we're all gone, that there's going to be a lot more audiovisual, that type of communication. So it just would behoove us to try to, for you guys to try to at least bring that up to your commission. I really would definitely make that a priority to see what are the accommodations that could be made for the public that want to communicate in a way that, if you didn't have that equipment there already, that's the problem. So people have seen public presentations on, PowerPoint. So that's the problem. The public sees that. They're like, why can't I do a 3-minute presentation too for equal access? So that's the thing that's a sticking point. And I understand the cost, but I feel like it's not really fair. That's how I feel.
Okay.
Member Sims.
I guess, I understand, Member Pippel, and I understand your argument regarding that there is no explicit language in the Sunshine Ordinance saying that for AV equipment or for this additional technology, there is no explicit equal access right, okay? I get that, but it's very it's kind of like the difference between what we would say a strict constructionist or Scalia constitutional interpretation and a Justice Kagan interpretation where it says, no, there is a right to privacy. And while we don't explicitly say there's a right to marriage in the Constitution, we all know that the founders meant that. And so my view is that when they specifically said prohibits the policy body from abridging or prohibiting public criticism of that policy, actions that might abridge, which your policy does, end up being a violation of 67.15. And I disagree in the fact that we should write a strongly worded letter because I don't think that will get to any action by the Library Commission. I think we should find a violation of 67.15 and make them at least come up with a policy that does not abridge. I don't think you should actually spend $40,000. I know you may disagree with me. I don't think you should go through all that detail. But I do think that you should come up with a policy that allows them to have limited access in some way so that if they want to have their speech heard, like the invited guest or the people who you agree with you more like are allowed to have that same access, that there is some leveling of the playing field. So I'm not asking for a lot.
Don't think of me like Scalia, more like,
Member Oka?
Ginsburg, maybe Breyer.
Okay, I like her better.
Aside from the staff time that would cost extra, I don't see the modification of equipment that you're talking about.
No.
I don't see that at all. There is no extra cost for bringing in other equipment. I don't see that. I don't see that at all. So 67.15 is what I will recommend we find as a violation.
Okay. All right, I'd like to maybe end this conversation and offer you guys the opportunity to offer any final comments or... Oh, I'm sorry.
One other question.
Member Highland, I didn't see you over there.
There's a reference in your letter to, we looked into providing a simple transparency device, but it wouldn't work because of where it would be projecting and therefore not everyone could see it. Can you give us a quick overview of what the room looks like? I'm assuming it's a rectangle with auditorium-style seating.
Yeah, it's an auditorium. I think that was referring to an overhead. We were looking at the possibility of having an overhead projector, and the problem with that is it does not project onto the TV tape. I mean, we don't have a connection. I mean, it would go up on the screen, but it would not be part of the record of the meeting. We don't televise, we record our meetings.
But I don't think that, well, go on.
No, we may be going to the same place. It sounds like your concern is really a policy concern, not a technological one.
Yeah,
I
it's
did want to
definitely
clarify, though, that I only offer the technological information just to understand that the challenge there is that imagine an auditorium with, in the first couple of rows, there's some seats removed, and somebody took a podium from, a very simple podium about half the size of this and plopped it down there. So there's no connectivity whatsoever.
Oh, I see what you're saying.
And we don't really want to just run cable on the surface of the concrete, which becomes a tripping hazard and is wonderful until somebody falls. So, just want you to know that we're not bringing up the aspect of the money, and I understand that we have a huge budget. It may not seem like very much money anyway, but it's not a number that was pulled out of thin air. We respectfully went out
definitely understand that.
and got a real estimate as close as we could get. But one of the concerns with the room is that Mr. Highland, your comment there is, we have also consulted with Mayor's Office of Disability and Carla Johnson there, and the only concern is that until you actually design the podium and the architects actually start measuring around it for clearances, then sometimes that triggers other things. Again, not a policy issue. It's just to understand that we grapple with, well, what will the fiscal impact of this whole thing be?
Okay.
And if anyone ever wants any more information about the construction end, I can always provide that. So.
Okay, thank you. Member David?
Yeah, I'm sorry. I just feel like I'm just missing one huge thing here. People do currently do PowerPoint presentations, right? They currently do.
Right.
So if the process for the public was the same, like send us your PowerPoint X days in advance, what physical changes need to be made to the area? Like, that's I'm missing that.
That would not require a physical change to the auditorium as it stands now. That would just be a matter of IT, and again,
That's what
I'm
I
not,
said.
it's their thing to assemble, because what they don't do is they don't do a whole bunch of separate, they just put the whole thing into a seamless file from one end to the other of the meeting, so.
That's
Okay,
fine.
thank you.
And then the person could get up to the podium. I have not been to that
It's
room.
a clicker.
Clicker, okay, thank you.
But there is an AV person on duty to facilitate, to troubleshoot, et cetera.
There is one AV person who has to be around.
And honestly, how hard could it be for that person to accommodate a member of the public who sent their PDF, or rather their PowerPoint ahead of time, pass the clicker to them? They step up and they do their thing.
Yeah, I understand, I'm fairly technological, so I understand the point that you're making. I think it's really just a question of staff time for IT to,
Got it.
I don't know if you've ever tried to put an Excel document in a PowerPoint and meld that with something else. You know how sometimes that actually seems like it should take 2 minutes and winds up
Takes
taking
long.
2 hours, right?
Well, I think, if
But
you
it's
if you
doable.
specify that it requires, that these media have to be in 5 days, 7 days in advance of a meeting, that staff time can be budgeted to accommodate that, how hard can that be?
Maybe, okay.
Well, I appreciate your comments.
Thank you, no,
very much.
thank you
Thank
for
you.
really explaining this to us, no, I understand. I'd like to offer, the rebuttal for, Mr. Hart, you chose not to do a rebuttal, correct? Yes, Mr. Hartz?
And I have
3 minutes.
3 minutes. I think the majority of the task force has it right on the nose. Basically, all I'm asking is the same equal treatment that other groups get. If they submit a PowerPoint presentation, I will submit a PowerPoint presentation. I only have 3 minutes. I'm not going to have 62 slides. I'm going to have 1 or 2 slides. And if I give it to them in the PowerPoint format, I don't know why they would have any more problem incorporating my 2 slides than they would all of the slides that all these other groups put in. If they're worried about viruses, several of you have mentioned the fact that the city has virus software in place. If they're really, 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 really worried that I'm going to try to do something to ruin their system, all they would have to do is print out the two PowerPoint slides and scan them with their own equipment. So there are ways of doing this, and the idea that it's going to take somebody hours to do it, if their IT people take hours to do something like this, then they have a problem with their IT people. And I don't think they do. I think they have very competent people who could do this very, very easily, but unfortunately the library and the Library Commission don't want dissenting opinion. They don't want me to get up after the Friends do a presentation where they talk about all the wonderful things they do, and me be able to get up and say, yeah, but you raised $6.5 million last year, and the library bottom line got $375,000. It's like those groups that we hear about all the time now where all the money goes to them and none of the money goes to the thing where everybody thinks it's going to. And the bottom line is, whether it's that or anything else, it's viewpoint discrimination. They just don't like what we have to say, and they want to prohibit us from being effective. So what they simply say is, it's going to, we're going to have to turn over the world. And they've repeatedly done this to me. They send these long, drawn-out things saying, Mr. Hartz wants us to completely gut the library, build a new building, a new auditorium, and, that's just prohibitive. No, Mr. Hartz just wants to send you a couple PowerPoint slides and ask you to incorporate them just the way you do with all the people you agree with. And I think you've all pretty well realized that's the bottom line there. And I appreciate that.
Thank you. At this time, I'd like to see if there is a motion to find a violation of the Sunshine Ordinance.
I would make a motion to find a violation of the Sunshine Ordinance, specifically with 67.15.
67.15.
D, yeah.
Do I, member,
sorry.
Attorney 3.
Just a suggestion, as on many occasions, it's helpful to make a finding of fact. If there's not a specific provision that specifically addresses it and it's a more general requirement, it's helpful to specify in the findings of fact how that violation happens to make it more enforceable in the end.
Well, I would then include that, making a finding of fact that by the Library Users Association, by the Library Commission, not allowing members of the public the equal access to aviation equipment, or a policy allowing such access, but allowing access to invited guests or those on the agenda who tend to have views that are affirmative to the Library Commission or positive toward the Library Commission. They're therefore prohibiting and abridging public criticism of policy, and therefore violating 67.15. To be more specific.
You asked, right?
Do I have a second?
Second. Madam Chair.
Okay. Seconded by Member Oka. Member Nee, you have a question or a comment?
Comment, actually. Section 67.15 contains 5 subdivisions, and I would respectfully suggest that we specify the subdivision as Section 67.15, Section A.
A.
That's my suggestion.
Actually,
But A, okay,
like
so,
D.
so you don't think it's 67D?
Well, that's certainly.
That's what you just made a motion about.
I'm fine with D. I was really,
Oh, I see.
throwing it open to discussion so
Bigger,
that we can,
general.
so that we can
Okay.
be more specific on what we're going for. And I do have one comment.
Okay.
With respect to the difficulty or the lack of reference in 6715 to the availability, making audiovisual equipment available to members of the public, I think an analogy can be drawn to the issue of school integration. There was no mandate that crosstown buses be used to integrate the schools, but they were seen as the tool for doing it. And in the same way, I think the use and availability of audiovisual equipment in order to maximize the opportunity for public comment on an egalitarian basis, I think the same thing can be said.
Okay, thank you. Member Sims, do you want to amend, because you had said 67.15D, correct? Yes, right, D. D as in dog. Do you want to change it to A, or are you fine with?
No, A and D.
Do you want to add, amend it, change it?
No, we could go A and D, yeah.
Okay. So you are amending it 67.15 to include, you had said D and you want to include A now.
A
A and D. Member Oka, are you okay with that? Because you seconded it.
Yes, I'm
Okay.
okay with that.
Great. Yes, I'm Gary. So next is public comment on this.
My name's William Ledford. I don't have anything with this, but I have to say that I find it not only a violation because of the fact that they're being very picky about who, but also I want to say shame, shame, shame on the library because I made the remark regarding having to make the amenities for the disabled. The library is supposed to already be that way. That's a violation of the Americans with Disabilities Act. Shame on them.
Thank you.
Absolutely.
Actually, because you were a member of it, I need to get public comment from people that haven't commented. Sorry.
Way back many years ago when I was reading your minutes on the internet, I felt really bad that people were attacking a public library. It kind of upset me, but in listening to things now, I guess they are some pretty serious things.
Thank you. Okay. Is more public comment? Great.
Hi, Diane Carpio, resident of Vicinity County of San Francisco. And I just wanted to say that thank you, Ray, for all your watchdog activities, and hopefully people will start taking note when you put in a simple request that there's more to it than policies and procedures are put into place for a reason. Laws are put into place for a reason, and when you let one slide, several more slide, and then it becomes a big problem. So I wanted to thank you. And any kind of negative connotation about a negative presentation, and I don't see Ray Hart's presentation as negative at all. I think they're enlightening. If they don't match a philosophy or people don't want to consider his opinion, that's one thing, but I took offense from his presentations as being presented as negative by, I can't see your name over there, Mr. Sims. Yes. Yeah. So I just wanted that on the record. Thank you.
Thank you. Is there any more public comment? Oh.
Peter Warfield, Library Users Association. I appreciate very much the comments and the questions that the task force has been making, and I barely dare to speak. If the Library Commission were to turn the lights out when Mr. Hartz or other people came up to the podium, after all, it costs money, and our library is so poor. If they were to turn the microphone off for Mr. Hartz or others because it's so expensive that they couldn't really provide that, and after all, there's no requirement in any law that says you have to keep the microphone on when I speak as compared with when somebody else speaks. I think you'd be pretty clear about what was going on. Now, in City Hall, the Board of Supervisors does it. You guys do it. You have folks showing things when you have a hearing that requires recordings, moving recordings. I think the library is expert at the dog ate it. Mr. Lombardi testified at one time at the Library Commission. He couldn't require his employees in the bathroom to sign that they had been in there and done some maintenance. Mr. Lombardi, it was beyond his ability to keep the men's room floor dry. On the other hand, Mr. Lombardi's people are able to wire up a conference room in a library where the Library Commission wants to have a remote meeting at one of the branches. There are wires like spaghetti all over the place, and they managed to do it. It's amazing. As for the library crying poor, this library is rich beyond belief. The voters passed Measure E in 1994, Library Preservation Fund, and again in 2007, which made this library have a guaranteed source of income from the general fund and a tax set aside. The most recent information that I have is that this library, out of 87 libraries serving 500,000 people or more in North America, is second in its per capita expenditures, and it's head and shoulders above most of the others. The one other library above our library has 15% more. We are spending $100 per capita per year, and that one spends $115. The next one down is $81. This library has more than double the funding and lots of money for all kinds of projects that I could tell you about that are not really very core. I think you got it. If they would give the same treatment to the public as they give to the Friends, that's all that's being asked.
Thank you. Is there any more public comment? If not, Madam Clerk, I'd like to take this to a roll call vote. And just so everyone's clear, will you repeat what we're voting on? The motion?
Sims Oka 67.15 A and D. The violation is the San Francisco Library for abridging public comment by not providing equal access of audiovisual equipment to invited parties and the public. I get verbatim once I listen to.
Oh, yeah. Not all right.
Okay.
Thank you.
You're welcome. Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Pilpel?
No?
Pilpel, no. Member Sims?
Aye.
Sims, aye. Member David?
Aye.
David, aye. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. Member Fisher?
Aye.
Fisher, aye. And Chair Grant?
Aye.
Chair Grant, aye. You have 8 ayes and 1 no.
So I'm going to refer this we did public comment, to compliance. And in hopes that, one, you can start the process of going back to your commission to get some, real kind of answers. But in the meantime, if someone is, has a request for audiovisual or something like that from the public, what you can accommodate in light of what you've been able to accommodate with invited guests, knowing that the public comment is limited to 3 minutes. Audiovisual for the basic stuff as well as the video. So that's it, pretty much. Okay? All right, thank you so much for coming.
Thank you.
Okay. Madam Clerk, go to the next item.
Mm-hmm. Item number 8, file number 13014, complaint filed by Ray Hartz Jr. against Ben Rosenfeld, city controller, for allegedly failing to provide filings by the city librarian Luz Herrera of gifts from the Friends of the San Francisco Public Library.
Okay. Member Pilpel?
Yeah, to Deputy City Attorney Threet, as you're walking out for a second, just want to be clear, it's Controller Ben Rosenfield. Ben Rosenfeld is the attorney who applied to be on the task force, and they're actually 2 different people. So I just want to be clear, it's Ben Rosenfield is city controller. And the continuation pages on the memo have the wrong header, Hartz versus librarian. So I just wanted to remind people if we can try to be really careful about.
So what are you saying, that in item 8 it's Ben Rosenfeld?
No,
Would be Ben
So
Rosenfield.
she wrote, our
The
administrator.
agenda is correct.
Yes.
It's the memo from the city attorney that I was referencing.
Okay.
And the continuation pages.
Okay.
Bad headers. All right.
So we'll make sure
Thank you
it's
very much.
corrected. Okay. So for this item, jurisdiction is not being contested by either party, right? Okay, thank you. So if I may get a motion to accept jurisdiction.
I'll make that motion.
Okay, can I get a second?
Second.
Thank you. Is there any public comment on this issue of jurisdiction? If not, then I believe I can say that this is, motion's passed without objection for jurisdiction. Oh, you do?
Are we going to have a break sometime soon? Thanks.
Okay, I'm going to go through this case, and then I'll do the break after this, since we're kind of like.
Sorry, guys.
Okay. So, since it's not been contested, the motion is accepted passed without objection. I'd like to invite Mr. Hartz up for his 5 minutes.
No public comment on?
Nobody wanted public comment.
Perfect, sorry, I missed that.
It was just on jurisdiction.
I was just blabbing away.
Members of the task force, Ray Hart's Department, San Francisco Open Government Director. There are a couple of things there that are clearly violations. I filed an immediate disclosure request, and it's in your packet, dated February the 8th. I hadn't heard anything for a week. I called and they said, oh, it'll be next week. And I left a message to have someone call me back, and they didn't. I waited another 10 days, called them back again. They said, oh, it's going to be next week. And again, I left a message. Nobody called me back. And finally, as you can see, on March the 4th, I get a response, and it's basically saying, we want an extension. Now, the extension should have been asked for by the close of business the following day, and it wasn't. And the extension, even if it was granted, would have only been for 10 days, and they've already gone past that too. So the bottom line is late response, certainty. And then there's the matter of what they responded with. You have in your packet 6 or 8 pages that they gave me, and if you look at them, they are all documents from the San Francisco Public Library to the Board of Supervisors. Nothing to the controller. And there are no documentations to show when any of these were sent supposedly to the controller. Now, I wanted to know specifically, what documents does the controller have reporting these gifts by the San Francisco Public Library? And instead, what I get is a bunch of documents that the library reported to the Board of Supervisors. Now, and I think this is what happened, because they made a comment in the email saying we have to confer with the library. My real feeling is what they did is they didn't have anything, didn't want to admit they didn't have anything, so they got in touch with the library. The library sent them these 8 pages, and they simply forwarded them to me. Now, they can prove me wrong. All they have to do is provide the transmittal documents. All of these were sent somehow, probably by email. If there's an email for each of these that says this was sent to the controller's office and it was sent contemporaneously for each of the years that is covered, then I would say fine. Then I know these documents were sent by the library, not just to the Board of Supervisors, but to the controller's office. But I don't have any of that. They've withheld that. So unless we want to assume these things sort of just appeared in somebody's inbox, they had to have gotten from the library to someone. And so my thing is that they've withheld documents because there's nothing here to indicate when these were sent, by whom they were sent, to whom they were sent. They are simply documents that I have gotten from the library, requesting them from the library. And again, from the Board of Supervisors, I wanted to know specifically what the controller had gotten from the library. And these documents don't answer that. They're simply documents that tell me nothing. Now, the question is you may say, well, what is the difference? If you got the documents, you got the documents. The bottom line is the law in the city requires that gifts be reported to the controller. There is a city attorney directive saying that these gifts must be reported to the controller. And I do not believe that these were reported to the controller. And I asked the controller, did you get reports? And if so, I want to see them. So we basically have an IDR which was not responded to on a timely basis. We have an IDR which was actually way beyond the extension. We have responses which really don't clearly indicate that all the documents were provided, only selected pages. And if these documents were provided by the library to the controller's office on an annual basis, because these cover 4 years, then there should be a document saying San Francisco Public Library to Controller Ben Rosenfield and the date. And so basically I'm saying it's no doubt in my mind that they have violated the ordinance in not responding on a timely basis. In fact, their attitude is just unbelievable lackadaisical. We'll get back to you next week. And then finally, the idea that it's not very clear when these documents actually showed up at their door. And so there had to have been transmittal documents, and those are missing.
Thank you.
Is there any member of the public that wants to offer any support or additional facts for Mr. Hartz? If not, I'd like to invite the Controller's Office up. Give you 5 minutes to state your side of the case.
Good evening. I'm Monique Zmuda, Deputy Controller, City and County. Mr. Hart is correct in that we did not provide the documents within the time specified, and that was a miscommunication within my office. With respect to the question as to whether or not these are controller's documents, Mr. Hart is correct that there is an administrative code requirement that departments submit an annual report of gifts received. Not all departments comply. In this instance, when we received the request, I simultaneously asked the head of the accounting department, who generally gets these reports, as well as the financial officer of the library, to please send to me the copies of the reports that have been filed pursuant to this requirement. So I did get some from the accounting division within our office. The chief financial officer was on vacation at the time, and I got an out-of-notice response, and so I waited. And it is the case that we should have notified Mr. Hart that we needed additional information because we needed to confer with the department and search for the records, and that was not done. And so I do apologize for that. We get many, many requests. We know what the process is. We know what it should be. And that was not done. When Mr. Hart did contact us 3 weeks or so later, by that time the chief financial officer had returned, had sent to me the reports that had been filed, and I sent them to Mr. Hart.
Okay. Thank you. Is there anyone that wants to offer any supportive facts from the public for Ms. Zmuda? If not, I'm going to open it up to the task force for any questions. Member Nee.
Yes, Mrs. Zmuda, please. You said that not every department is compliant in terms of reporting the gifts that they're supposed to report. Is that correct?
I did say that, yes.
Okay. What processes or procedures or what do you have in place to go after to go after those departments?
It is a good question, which we asked ourselves as well. In one instance, we found in doing an audit that there had been some gifts received that were never reported, and so for that particular department, we made sure that those annual reports are submitted. We do know that the library had submitted reports on a regular basis. I believe there was 1 year that was missed because of, I am assuming, an oversight. We know those departments that tend to get gifts, and we approach them on an annual basis during the year-end close to submit the reports.
Do you, when you don't receive a report that is required, that you know there's some data out there, you know it should be reported to you, and it's not, do you file any kind of report on that with the city attorney's office or with the board of supervisors? What do you do, if anything, to try to effect compliance with the departments that are recalcitrant?
It really depends on the requirement. For something like submitting the budget on time or submitting other financial records that are required for rating agencies and other things like that. I mean, we're on top of that on an immediate basis. The gift report is an important one, and we do look at the end of every fiscal year, and we expect the reports from some departments that continually receive gifts. If someone provides a gift to a department and we don't expect it, and they either don't know or don't file a report, it might be a while before we discover that. But we do think that we have most of the departments that get gifts in a routine now to submit the reports with their year-end close information.
What kinds of carrots or sticks do you have? I mean, are there any departments out there that are repeatedly in violation on this?
Not in the recent past. The carrot and stick issue is an important one. I do think that the Controller's Office does have a number of carrots and a number of sticks, and we audit departments based on their performance. If we find that departments are either having problems in balancing their budget, or they're having revenue shortfalls, or they're having problems in putting financial transactions in the system properly, those are flags that would trigger a review or an audit of the controller of that function. And also, we manage their balancing of their budget on a monthly basis. We provide allotments for how much money they can spend, and if we find they're not spending appropriately, then we can apply those restrictions on departments.
Okay.
But generally, we prefer to educate and to provide technical assistance rather than the stick.
Thanks.
Member Pope? Oh. Member David?
I'll defer.
Okay. Hey, Ms. Samuda, I'm just curious, in this particular case, was the public library, did they file the reports on time, or did you need to go back to them and ask for the past reports?
I believe there was one missing from our stack, but the others were reported on a timely basis.
So the delay in getting it to Mr. Hart's was truly an unfortunate situation inside of the controller's office. You were not waiting on the San Francisco Public Libraries. It was as you said at your opening statement, like there was an internal issue. Is that correct?
Yes, so what I wanted to do is I wanted to compare the reports that we had with the reports that they had filed to make sure that I was providing all of the information that was available.
Okay, thank you.
Member Pilpel?
So it seems to me that this is actually a bit of an issue of internal controls. Is this one of the issues that gets looked at by the outside auditors and in checking our system of internal controls, or is it more?
What the auditor does is the auditor looks at all revenue sources that come into a department, including gifts, and if there are restricted gifts, then the auditor would do some testing to be sure that those gifts are spent in accordance with the requirements. They do not audit whether or not a report has been submitted.
Okay.
That's
So
an
the
internal thing
reporting-
that we work on.
Yeah, the reporting requirement is really more of an internal city.
Correct. Procedure.
Okay. Which is subject to the controller's procedures.
Correct.
Manuals and directives, and
That's right.
which, of course, some of us are familiar with, and others, never mind. These reports only cover gifts up to $10,000 in amount. Above 10,000 requires.
In excess of, correct.
Okay, above 10,000 requires approval by the commission. Above 50 or 100,000 requires accept and expend from the board. Whatever. They're
I
various
believe the threshold for the Board of Supervisors to approve it, I want to say 25,000.
No,
I'd have to
25?
check.
Okay.
But there is a threshold under which the departments may accept gifts and merely report them rather than have them approved by another body.
Okay, and there is some threshold in the middle that's not subject to just the department head's approval, but is actually their commission. So in
Yes.
some cases,
Yes.
if it's between the 10 and 25, it may be that the library commission has to accept a gift or a gift in place. Or,
And it may be that the commission accepts all of the gifts.
okay.
I think that's probably more likely.
Depends on the policy of that body. Okay. So with respect to why the Friends of the Library is not on this report in all instances, it may be that whatever transaction occurred between the Friends and the library occurred pursuant to an agreement and wasn't an outright gift. They have various agreements between the library and the Friends. Is that correct?
Yes, and I do know that the Friends of the Library also provide some in-kind services, and there was a question, a legal question about whether or not that constituted a gift, and so I think that some recent legislation has been approved that clarifies that.
So it's possible that not all gifts from the Friends will be reported through this process. This does not, the point is, this does not capture all gifts. It only captures gifts less than $10,000 in aggregate during a fiscal year.
I'm just going to check because not all departments report it the same way.
Okay.
And Mr. Oka has a question after that.
Yes, it would appear that all of these are limited to those that are under the threshold whereby they would have needed additional approvals for acceptance of the gifts.
Okay, but you did concede that there was a timeliness issue, so we may
Okay.
find that violation. All right, thank you.
Member Oka?
Yes. As I understand it, the bulk of the gifts given by the Friends of the Library don't appear on the reports that you received. Is that correct?
I cannot speak to that without truly taking a look at all of the gifts. I understood the questioning here is whether or not we received the reports and whether they were timely.
Can you tell me how much, what the amount reported to your office was from the library?
Well, there are a number of reports, one for each fiscal year, calendar year rather. So the latest report dated February 13th, 2013. The items are rather small, and it's not totaled, but there are probably about 10 items or so, range in value between $5 and $9,378.
Okay, thank you.
They're relatively small items.
Okay, thank you.
Okay. Member Washburn?
Right, I guess I'm confused about why the amounts are so small. It seems, I thought the library had a lot of money and got a lot of money from the Friends and from other donors, and what we have here is the aggregate over all these years. It's not a lot of money. It's probably under $50,000. So is this all you have?
These are all the reports that were received by the library, yes.
It seems to me that there's a lot missing here. There must be.
I mean, there are, as Mr. Pilpel already noted, there are other ways to accept gifts other than just providing it in a report. So that formal process might take place over the course of the year. So if there was a very large donation, for example, that needed Board of Supervisors approval, that gift would be received through that mechanism.
So it wouldn't show up in the controller's office and be part of the financial data that you keep for the library?
It would, but it is not part of the reports that are generated by the airport and reported to the controller. The point of the administrative code section is for the department to report to the controller those gifts that the department has the ability to accept on its own behalf.
I see.
Member Sims? Do you have a question? You don't have any more?
When he asked for any and all supporting documents, what did you interpret that he wanted with that? Because it does seem like you did comply with, albeit late, the annual report documents, but he also requested, Mr. Hart's, the any and all supporting documents, and I don't know if that was actually.
We had no other supporting documents.
Okay.
It was the transmittal letter and the one page that identified the gifts.
Okay.
We provided everything that we have.
So there were no additional transmittal letters or anything like that
No.
that he was asking for. Okay,
No.
perfect.
Great. Member David? Did you have a question? No? Okay. If there are no other questions?
Well, I have questions for Mr. Hartz.
Oh, that's
Yeah.
Mr.
Mr.
Hart,
Hartz?
sorry.
So, do you feel that there were documents that you did not receive that you requested in your IDR?
Yes.
Okay.
Specifically, if I send a report to somebody in the city, I'm normally going to do it by email. I'm going to send them an email saying attached is the report for 2008, 2009 covering this.
Uh-huh.
And I feel those are public record. They are a part of the document, and they establish clearly when this report for that particular year was sent.
So you're saying, for example, her email contacting, if she emailed, for example, the Library Users Association saying, or requested someone to email the Library Users, not the Library Users Association, the Library Commission, or the public library, asking for certain documents, that request email should absolutely be included in your
in the response.
In the response.
Yes.
Okay.
Either way, if each year they were sending these documents, these four years, covering 4 years, each year there should be a transmittal document saying here's the report for 2008, 2009. In fact, in this case, since it's addressed specifically from the library to the Board of Supervisors, I would probably, as a person submitting these, say, I'm simply sending you a copy of what we send to the Board of Supervisors. If you need anything else, let us know, or something like that.
Yeah.
Now, if I had gotten these 8 pages, and each two-page document had an email attachment showing 2004, 2005, 2005, 2006, and so forth, I would know that they were contemporaneous records, which is what the law requires. And if I had gotten an email cover sheet from the library saying, oh, here's the 4 years of documents, I would know that that's exactly what it is. They went to the library and said, we don't want to have to tell Mr. Hartz we don't have anything because, as already has been established, it's required that you report to this. So send us stuff real quick, and we'll just pass it on to Mr. Hartz without any cover sheet and hope that he just accepts the fact that these were probably given to us each year.
Do you want to respond?
I mean, I don't know why there's such distrust, but that's kind of not my issue.
Yeah.
We provided to Mr. Hart exactly what we received. And yes, some departments provide a cover letter. Yes, some departments think that they need to present the report to the Board of Supervisors and just give us a CC. Any transmittal letters between me and Ms. Singleton, who's the Chief Financial Officer, I didn't think to keep it. It was just, please send me this information, and she sent it to me. And so again, I did provide to Mr. Hartz everything that we have in our office, and there is nothing else. No one made up any dates. Those reports were filed on the date that they were received. On that date, whether it's whatever fiscal year, and I don't have any reason to question that.
Member Pilpel?
To clarify, I just looked up the admin code section. I'm one of those kind of people.
I know.
It's actually not 10.100-302. It appears to be 10.100-305, San Francisco gift funds. All such gifts will be promptly reported to the controller, and then there's an exception in sub B. 10,000, greater than 10,000 shall require approval of the Board of Supes by resolution. And then each department shall furnish to the Board of Supes within the first 2 weeks of July a report showing such gifts received and the disposition thereof. So that the annual report requirement appears to be to the Board of to the Board of Supes, but each such gift is supposed to be promptly reported to the controller, presumably throughout the fiscal year pursuant to however you handle that. Anyway, I'm sure you're going to look at this section and how better to facilitate its interpretation, I guess.
No, I mean, you're correct that it is, we've always looked for the reports at fiscal year end. So in the July timeframe, and that's usually when they come in.
But this also suggests that there's some contemporaneous reporting from departments to the controller. It says will be promptly reported, and that's separate from the annual report requirement to the Board of Soups. Anyway, you may want to just look at...
We do look for them once a year.
Okay.
Yeah.
Great. Are there any more
Thank you very
questions? If not, Ms. Muda, if you have any final comments?
I do not. Thank
Okay.
you.
Mr. Hart? Final comments, 3 minutes.
I think it really comes down, Ms. Muda says, I don't understand why there's this distrust. When you get an IDR and it takes them a month to respond to it, and the response is, we want an extension, and then it takes them several more days to actually get you, they say, because we have to do all this extensive research, and what they actually give you is 8 pages. You kind of look at it askance and say, that's a little funny. And the transmittal documents are public records. These documents made their way from the library to the controller in some method. They weren't put into a magical envelope that appeared in Ms. Muda's or somebody else's at the controller's office box. They were transmitted some way. And normally when someone sends a transmittal letter, they just don't send the document and say, here's a document. It normally says, here's the report we're required to file on an annual basis. So where are the documents that would normally show when this actually made? And she said, oh, well, there's dates on there. But when did they file these? Did they file them, as Mr. Pilpel pointed out, within the time limit? Did they file them 6 months late? I'll tell you right now that the Friends files their annual report with the State Department of Charities typically 9 months after the deadline date. And so basically what I'm saying is there's a lot of irregularities. Now, I'll be honest with you. How much time do I have left?
1:22.
Thank you. I'm actually kind of pleased with the documents I've got, because I have lists and lists and lists of gifts, transportation, accommodation, registration fees that the Friends have given to San Francisco Public Library employees, including the head of the Library Commission, got a $1,340 trip one year. Mr. Luis Herrera got trips. And there's all these questions about the fact that none of these have been reported to anybody. And you see these reports here. These are all these gifts supposedly up to $10,000, and yet here we all have all these trips, accommodation, transportation, taxi reimbursement, meal reimbursement, and all this other stuff that were given to all these dozens, literally, of city employees, none of which was reported to the controller. And as far as the public records request, none of it has been reported to anybody. So basically what it looks like to me is they filed a report just to say we filed a report and just left out a lot of the information. We're talking about a group that between 2000 and now has expended over $60 million. Every year they give $375,000 approximately to the Friends for things like discretionary spending by the city librarian, spending by the branch libraries and so forth, and none of that is reported to anybody.
Thank you very much. Is there a motion to find a violation of the Sunshine Ordinance? Member Pilpel?
I would so move to find a violation of Section 67.21B and 67.25A related to timeliness.
Do I have a second?
21B and 25A. These are the same actions with respect to the Arts Commission from earlier. But I need a second.
We need a second.
Second.
Great. I'd like to open up for any discussion. Member David?
Yeah, so I mean, this is the second case that we've had tonight where a government agency, local, San Francisco, has come up and said, yes, we did not respond in a timely fashion. And so, like, yeah, okay, what I'm kind of struggling with is if they internally know that, can we find them in violation and close the case at that point? Like I'm a little bit like, okay, we're going to send them to EOTC for them to say, we know that we violated. So, yeah, I'm just kind of like, I'm a little bit confused about yes, they violated. Can we say they violated and say that's the end of the case, or do we have to send them somewhere once they violated?
Member Nee, and then Member Washington.
Yeah, well, there are things I think we can do. EOTC, it seems to me, would be a logical next step, and EOTC can, help the controller's office develop some policies and procedures and practices for making sure that responses to public information requests become timely on a permanent basis. And then, if there are subsequent complaints based on that particular kind of violation, we can draw some conclusions from that, and perhaps send the matter onto the Ethics Commission for some kind of enforcement or disciplinary action.
Attorney Threet?
Through the chair, not to speak specifically to this one, but to the different options available. In cases where you find that there's a violation of the ordinance where a public record has not been provided that was requested, the order typically states that the document should be provided within 5 days, and it certainly is most appropriate in those cases that the matter go to compliance and amendments to follow up on whether that order was complied with, and if not, to decide how to deal with that. In other cases where there was a violation that, for instance, it was late, or perhaps documents weren't initially provided but were subsequently provided, sometimes at the discretion of the chair, the more in the respondent indicates there was some inadvertence, or it's clear that there wasn't willful violation. It's often been the case that the chair will refer to EOT to talk about how that can be avoided in the future. And there's no requirement that it be either or. And so there have been cases before the task force where there's been more than one violation, and portions of it were sent to EOT to look at that, and to compliance and amendments to follow up on whether there was compliance with providing the documents.
Thank you.
Member Washburn?
Another thing we've done recently, the prior task force, a couple of the members, so one of them would do a press release after our meetings announcing our determinations. So that would be one way to just inform the larger public about what we found. That might exert some, subtle encouragement to do better in the future.
On this particular case, I'd love to hear from what you guys think.
No, I
understand.
Yeah, I was just wondering what our set of options were.
Mm-hmm.
That's all.
So I can find a violation and conclude it.
You cannot.
I cannot. I have to. Attorney Threet, so according to what you just said, generally we give it to you. I can do either or. I could conclude it just as a matter of point of fact, that we find a violation. Do I have to? So the remedy is that, because it is going to go to EOTC or...
The referral is generally at the discretion of the chair, although all decisions that are at the discretion of the chair can be overruled by a motion of the task force.
Got it.
So, I guess it
have a question?
makes sense to me that if we do find this violation, we would probably send it to EOT, and we would talk through the procedures with the controller's office to
try to avoid
see
this.
to see how things are tracked and to try to avoid this in the future.
Perfect. Member Okay?
If we find a violation and do nothing, let's take a look at what that makes us look like. If we sit and say we found a violation, but we chose only to send a letter, what does that make us look like?
Yeah.
Doesn't make us look very good right now.
Yeah. No, I was just asking.
That's what I want to avoid.
Okay. Got it.
And I have to respectfully disagree with this. Like, our job is not to whether we look good or whether we look bad. Our job is to make sure that the public is getting the information that they are requesting.
Right.
And in this situation, it sounds like that I believe that at the end of the day, that it took a much longer time than it should have taken, but that Mr. Hart's got the information that he was looking for. Now, he might feel that there is additional information that is there that he's not receiving, and that is up for debate. And so that, that's a different question altogether. So I just want to say that it's not that I don't agree that just because we would. If I felt that the public got the information that they received, that therefore we should all spend time, at EOTC making sure that there are I just disagree with that on principle. That's respectfully disagree.
Got it.
Okay.
Okay. Thank you.
I would point out that we are not doing our job if we just slap agencies on the wrists and say, you better do better next time. That is not going to be good enough, in my estimation. If we are really doing our job and making the public aware of the transparency of the city's agencies as it should be, then we must put some weight behind our decisions.
Yes. Clearly, jail time is definitely what's called for in these situations. I agree 100%.
Okay. If there's no more comment from the task force, I'd like to open this up to public comment. Is there any?
Well, I did have a comment. I do believe that there were some documents that perhaps should have been produced. In my view, if you are responding to a public record request and you are having to email, any correspondence regarding that request should also be produced, even though, especially when it says any and all supporting documents, because that would be inclusive of those documents. I think as a course, even though I don't know if the ordinance actually specifically requires you to produce that, absent the any and all supporting documents. I think that that members of who serve the public should produce those documents. But I mean, go ahead.
So, but this, I agree with what you're saying, but this is a motion about, remember, this is the motion about timeliness. That's why we're...
The timeliness, I agree with the timeliness. But
so, okay.
Yeah.
And I think we heard that there were no supporting documents.
That she gave everything.
Yes,
that
she said that. Right.
Attorney 3.
So there may be dispute among task force members about whether there are additional documents. The way to proceed is to request that the maker of the motion accept a friendly amendment. If he refuses, then you can seek to amend his motion, or you can make a separate motion after voting.
I don't know at this point if I have enough to convince me to make a motion. I definitely have some doubt. I'm not 100% or maybe over the threshold to make a motion at this point.
So in that case, let's go to public comment on this particular motion.
The timeliness.
The timeliness factor. Let me get the correct. It's 67.21B, and what else was the other one?
25A.
25A, and 67.25A regarding the timeliness, which Ms. Muda has definitely admitted to not complying with.
I'm Peter Warfield, Library Users Association. I'm not a party to this complaint, and I haven't followed it closely. But first off, I would agree with and support the motion. In case you don't get to it later, I think 67.29-7, correspondence and records shall be maintained, I think is something that you should very strongly consider. So there were a couple of things that I thought were rather interesting here. In my very limited experience with the controller, my general experience has been that the controller has a steel vice grip on a whole range of materials, financial, and knows where they are. So I was very puzzled when Ms. Muda said that the controller had to check with the library to make sure that they had all of the materials. Mr. Hartz did not ask them to check with the library. He didn't ask for a joint effort. He was very clear. He wanted to see copies of all reports of gifts, including any and all supporting documents, filed by or on behalf of City Librarian Luis Herrera. And I would think that since it's a statutory requirement for the controller to receive these materials, that the controller would have an organized way of maintaining these things and would not have to confer with the library as one of the reasons why it took so long. On the contrary, it seems to me that this is essentially what might be, if you want to call it mistrust, a cover-up to make sure that everybody's stories match up. Now, the section of the law requires promptness, and so timeliness is of the essence as to whether the ordinance has been complied with. And I can't imagine good record keeping would destroy the evidence of timeliness. Now, it seems to me if somebody hand carries something in, I don't know what the controller's procedures are. I don't have to file anything with the controller, but there's plenty of places that have a date stamp. If the stuff walked in the door or somebody slipped it under the door at lunchtime when nobody was there, except the controller's office is open, by whatever means, presumably there would be some indication of when it was received. Furthermore, Ms. Muda says that we expect from certain departments, and the library obviously is one of them, to get these things regularly, and we look for them, and we remind them. Well, here is a report from Maureen Singleton that it's been a year since they got the report. What happened with the controller? It's clear what Mr. Hartz wanted.
Sorry,
he should have gotten it, and I ask you to make an order out of this, an order to require the controller to turn everything over. Thank you.
Thank you. Is there any more public comment? If not, did you want to say something? Okay. I'd like to take a vote on the motion that's on the table right now.
Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Pilpel?
Aye.
Pilpel, aye. Member Sims?
Aye.
Sims, aye. Member David?
Aye.
David, aye. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. Member Fisher?
Aye.
Fisher, aye. Chair Grant?
Aye.
You have 9 ayes.
Great. I am going to refer this to EOT for, analysis of the process, something that can help them.
Chair Grant, can I
Yes.
just offer a suggestion through the chair?
Yeah.
That if there is any additional documents, meaning cover pages or date stamps or anything like that, that to please ask Ms. Samuda to provide that when she comes to the EOTC. If they don't exist, great, but if there is something like that that has, it would be fantastic to include those.
Okay.
Okay.
Okay. Is that fair enough? Thank you. Okay.
Thank you.
I would like to, I know it requested a break, but I would, for the two parties that are here, I'd like to ask if you can, do you just want to go straight through? I'm down to go straight through. Say it again?
Let's take a break.
Oh, you want to take a break? Oh, okay. So I'm going to take a quick 5-minute break then? Okay, thank you. So we will come back here at about 9:07. Jerry, are you leaving?
All right. Chris has got to go.
Chris has to, I know.